claim still cannot succeed. In short, the plaintiff's claim fails at every step, and the judgment below should be vacated or reversed. Let me begin with the question of jurisdiction. The plaintiffs are incorrect to argue that the city's appeal is moot. The mootness question turns on whether on appeal, the appellate mootness jurisdiction question turns on whether a district court judgment or injunction is imposing a continued injury in fact that is redressable in this court's appellate powers. The answer here is yes. The district court's injunction requires the city to utilize a redistricting plan that the city has not adopted and against the city's will.
So it's your position that the case is moot, but the appeal is not. Is that correct?
That is correct, Your Honor. The plaintiff's claim is moot because that turns on the challenge system, whether that is imposing a continued injury in fact. By contrast, the appellate jurisdiction question turns on whether the judgment below in the injunction is imposing an injury in fact.
Can I ask you a question about the case being moot? And I think I understand your position on this. But this, I guess, is my question. If I were trying to figure out why maybe it's not moot, this is where I end up. So the district court found that at-large elections in this district, because of block voting, are dilutive in violation of Section 2. And if that's right, then what about these remaining 3 seats that are at-large? Don't they also violate Section 2 so that we could provide relief by affirming the district court's plan?
The answer, Your Honor, is we certainly do not know that. That's not how the Voting Rights Act analysis works. Under Johnson versus DeGrande, Jingles, League of Latin American Citizens versus Perry, multiple cases hold that it's a comparison of the number of opportunity districts in the challenged plan as compared to the number of opportunity districts in a remedial plan, a proposed illustrative that is provided by the plaintiffs. So what the district court held precisely, and you see this very vividly at Joint Appendix 1146 and 1154 through 55, was an 11-member scheme. I think it's more probably viewed as a 10-member scheme, but they're all at-large seats in any event. And the district court effectively believes and holds that there's no opportunity districts in that system. But a system with 3 at-large seats is fundamentally different because there are 7 remaining seats. Well, we don't know what those are. We don't know if they will perform as opportunity districts. They don't even exist. That argument isn't right. And it's significant, of course, that the district court's opinion doesn't say anything about a 7-3 system. It doesn't say that wouldn't work, that would violate Section 2. And of course, it's in no position to do that. What the district court's decision focuses on, of course, is the plan that was identified in the complaint. All the evidence concerned that plan, and that plan is no longer in existence. So you see an advisory opinion opining that a system that will never be used again is violative of Section 2. The law is clear, including this court's Valero Terrestrial Corporation case, the Esposito case, the Supreme Court's New York State Rifle case, that any argument that the plaintiff may have in the future about this future 7-3 system, whatever it may be, can and must be brought in a new case against that system. With that, I would like to turn to the merits, if I may. Obviously, there's been a lot written by distinguished Article 3 jurists on the question of coalitional claims in Section 2. I'm only going to add so much this morning. I want to take a few minutes just to clarify our position, because what you see in the plaintiffs and their amicus's briefing, I think, is a lot of straw man attacks on argument that we are not making. Our position is not that Section 2 of the Voting Rights Act protects only one minority group at a time. Our position is that in a coalition claim, you have a fundamentally different problem, because none of the groups standing alone, none of the voters standing alone, can allege that they are denied or abridged in their right to vote on account of their personal race or color. It's only by viewing all of these groups together that the coalition claim comes into existence. And that's what makes these claims difficult under the statutory language. I think the crux of the matter is that the plaintiffs and their amicus want to read in a white, non-white distinction into the act, and they want the act to say on account of not being white. But that's not what the act says. It says on account of race or color, and that's personal to the voter. And Congress, in fact, knew how to say.
So is it your position that to have standing, at least one person of every race in the minority community would have to join the lawsuit?
That is our position, Your Honor. That's our third-party standing argument. I apologize for skipping over it. I'm trying to get to as much as I can. But our position is very simple. There has to be a nexus between the claim and the people who are bringing the claim. This is a coalition claim. I think it's a modest proposal. Yes, Your Honor.
Is your third-party standing argument, I mean, that collapses into your merits argument about the coalitional claims, doesn't it? If it were permissible to bring coalitional claims, then why wouldn't it be sufficient that you have one plaintiff in the coalition? I understand how it does dovetail with your merits argument, but are they really separate arguments?
I think they are in the relevant sense, right? We're not, for purposes of third-party standing, we're assuming that there is a claim that's cognizable. We're assuming they can even prove it. That's not what we're saying. We're not challenging the merits, but according to Flass versus Cohen and many other cases, there is an analysis looking at what that claim is to see if that person is the right person to be bringing the claim. A coalition claim still recognizes, even on its own terms, assuming it's valid, assuming it can be proven, it still recognizes that there are different groups. We know this because Grow, the Supreme Court said so in Grow. It said these are distinct groups that are coming together. A coalition means you have different groups at the table. Everyone's represented, everyone's present. And what the problem here today is that we are litigating a claim about the rights of persons, Asian American and Hispanic voters. That's their voting rights. That's personal to them. We're litigating them, and they're not here. They're not.
Would it be any more representative if just one person from those groups was the person who brought the suit? Is it really practically any difference? You're saying that it's resolved if you had one person from each of the constituent minority groups that would solve the problem, and that would be more representative because one Hispanic person brought the suit, then it would speak for it. What do you? Who has to bring it? Everybody? The statute says any citizen, singular. Does it not?
I'm not. I agree with Your Honor. And
okay. Well, I'm just trying to understand. You said, how do you cure it? We need each person. I thought in response to Judge Thacker, you were saying you needed each person from the constituent minority or race or color class has to be that. You're not saying, well, clarify that for me.
Thank you for allowing me to clarify. I'm not saying every voter has to be brought. I'm not saying it has to be a class action lawsuit. What I am saying.
I didn't say every voter. I said one person from that group. Are you saying that?
And I agree with that.
That's now requiring that.
Yes, and I think that.
Well, how is one person any more representative than another minority person who has, as found here, has also historically and present still has a sting of discrimination and block voting?
The same way that one person makes a difference in a single race claim, two voters.
But the difference is the proof. As Judge Harris was saying, are you conflating the ability to have standing to bring the suit with the merits of whether or not you can prove? Because cohesiveness and all those things, it doesn't mean you made it through, but you bring under the statute any citizen, it says, and then of course you have to show cohesiveness and all of those things, and then you rightfully say, well, how do you know that? Well, how do you know that? As you have done here. But you're saying ab initio, a coalition claim cannot be brought. Is that right?
That's our third-party standing position. We're arguing all of it, right? I mean, we are challenging on the merits. I'm about out of my time, so I'll try to get to cohesion and rebuttal. But that is our position, and I think this goes to the fundamental problem that the Fifth Circuit recognized in Lulac versus Clements. And I say I'm getting my rebuttal time, but I just say one more word about this. In Lulac versus Clements at footnote 33, it acknowledges that these claims can have problems. They are fraught with risks, including the risk that one group may not actually have other groups' interests in mind. We have a very modest proposal that you need a coalition to bring a coalition claim. Thank you, Your Honors.
Thank you. Mr. Malley? Ms. Malley?
Thank you, Your Honor, and may it please the court, Erica Maley, on behalf of the Commonwealth of Virginia, representing the amicus. I'd first like to briefly address the argument that the appeal is moot. The Commonwealth agrees with the city that its compliance with the injunction pending the appeal does not moot the appeal. And under the Virginia Voting Rights Act, the fact that the city obtained pre-clearance of the plan that the district court ordered would not bar the city from now seeking to adopt a new plan, and it would simply have to obtain pre-clearance of any new plan under the same standards. Turning to the merits arguments, the circuits are split as to whether,
Counsel, I'm sorry, before you leave mootness, can I just ask you a couple of questions? So the city's position is that under state law, it's really impossible for it to revert back to an all at-large election system. Is that your understanding also?
We hadn't actually weighed in on that precise mootness argument in our briefing, but I believe we agree with the city's position on that.
And it was passage of HB, is it 2198, the law that the city believes has mooted out this case. Was passage of that law at all related to this litigation? Do you know?
I can't make any representations about that. I'm not aware of the history of that act one way or another. I know it was passed in 2021.
Okay.
On the merits of the claim, the circuits are split as to whether coalition claims are cognizable at all under the Voting Rights Act. However, every circuit that has allowed such claims has also required a heightened showing of cohesion, that each group within the purported coalition is cohesive and is cohesive with the other groups. That follows from the Supreme Court's holding in Grove versus Emerson that if coalition claims are cognizable, a question that the court expressly reserved, then a heightened cohesion showing is obviously required. Here, the district court instead erred it. Without a distinct analysis of each group in a purported coalition, such a claim threatens to create by judicial fiat the very type of harm that the Voting Rights Act was intended to prevent, thwarting the voting preferences of a distinct minority group by submerging it within a larger group of a different race that has different voting preferences. That risk is not only a theoretical one here. The very evidence that the district court relied upon to find cohesion, in fact, strongly suggests that that is what occurred.
Counsel, I'm sorry, can I just take you back to what you said before? Just in practical terms, what is the harm on your theory? What is the harm to Hispanic and Asian voters here?
Well, if Hispanic and Asian voters, in fact, have different voting preferences than the Black voters do, they're a much smaller element of the minority.
But so what? I don't understand. Does it hurt them to be put in a district with Black voters?
It could, yes. You could be essentially diluting their vote.
Well, then they can bring a claim, right? And say, my vote has now been diluted. I've been cracked and packed or whatever.
But
is there any reason to think that I don't understand. What would a claim like that look like?
Well, we're not saying that they would necessarily have a claim because they wouldn't. The harm would be that otherwise they might have been in a different district with a greater chance of achieving their voting preferences. And instead you're putting them in
That's always the case. Every time they redistrict my state, I might have been in a different district or I would have a greater chance of bringing to pass my voting preferences, but we don't usually think of that as an injury to
You
a
might
voter.
be, but you're purportedly remedying a thwarting of their voting preferences. But if they don't share the voting preferences of the coalition, you're not. You're actually thwarting them because—
What is this, like a dignitary injury? Like they've been harmed because someone is making assumptions about how they vote?
There is that, but you're certainly not remedying any dilution of their votes because they have—
I understand that on your theory, you are not remedying any dilution of their votes, but I am not catching, or I am not understanding the part about, you seem to be suggesting that they would be actually in a concrete way injured if this claim went forward. And I'm trying to get my hands around what that looks like.
They could be if in the ex-ante world, they would have been in a district that reflected their voting preferences, and now they're in a district that is not. But we're not saying they necessarily would themselves have a claim. We're saying that a coalition claim where there is no showing that the different groups within the coalition are cohesive, you are not actually furthering the purposes of the Voting Rights Act. Thank you, Your Honor.
Thank you. Mr. Lamar.
Thank you, Your Honor. Good morning, Your Honors. May it please the court. Chris Lamar appearing on behalf of Plaintiff Appellees. This court should reject the city's appeal for 3 reasons. First, the parties agree that this appeal is moot. Second, the district court's factual findings and ultimate conclusions.
I don't think the parties agree that the appeal is moot.
Well, Your Honor,
You just argued it's not moot.
Well, Your Honor,
The case is moot.
Your Honor, in their reply brief, and this sort of gets to Judge Harris's question that she asked earlier about the HB 2198 measure. The city abandons the argument in their reply that HB 2198 is what makes this case moot. Instead, what they say is that HB 2198 combined with the broader protections under the Virginia Voting Rights Act is enough to make this case moot. That's not quite right. We agree that the Virginia Voting Rights Act is the key measure here. And that is because the Virginia Voting Rights Act has several requirements that the city has to comply with that are separate from Section 2. And to comply with the Virginia Voting Rights Act, the city submitted for pre-clearance the 10-1 remedial map from the district court. And the Attorney General granted pre-clearance in part because the remedial map includes 3 opportunities to elect districts. The last part here that's important is that the Virginia Voting Rights Act includes a retrogression component. And what that simply means is that once the city takes a step forward to protect the minority community's voting strength, it cannot then take a step back.
And you know what, Mr. Lamar, I interrupted you when you were doing your 3 reasons. If you want to go back to those.
I'm happy to continue talking about
Can I ask you a question about mootness? Because it does seem to me, Judge Thacker, of course, is right that one of you, at least mostly, is arguing the case is moot. One of you is arguing the appeal is moot. But either way, you both agree we should not be hearing this case. And it seems to me that the result would be the same either way, that we would have to vacate the district court order because the city, through no fault of its own, has now been deprived of the right to appeal not only a judgment against it, but an actual federal court injunction managing its elections. So why does it matter which theory of mootness we're using if it's going to end up in the same place?
Well, Your Honor, the parties here haven't briefed the vacater issue. I think it might be helpful for this court if the parties engage in further briefing on this issue. But even turning to the law on this case, the Supreme Court has held that vacater turns on the specific facts and circumstances of each case. And the public interest here in terms of the precedential value of the district court, the well-reasoned district court order about Section 2 claims for coalitional claims, for example, is very valuable. I think, secondly, Your Honor, in the remedial phase, the city had ample opportunity to submit a non-dilutive map to the district court that would comply both with Section 2 and the Virginia Voting Rights Act. In the remedial phase, and the city doesn't discuss this, but in the remedial phase, the city submitted to the special master a 7-district plan that the special master described as being wholly insufficient in remedying the violation. So not only did the city have the chance to submit a plan that wouldn't dilute the minority community's voting strength to...
But by the time the district court entered its order, the case was arguably already mooted by the change in the Virginia law, isn't it?
Yeah, well, I think that's possible, Your Honor. I think our concern here, quite frankly, when we're discussing when does this case become moot, becomes a question, quite frankly, of attorney's fees, and when is the city responsible for paying attorney's fees in this case?
But so in terms of the Virginia's law didn't outlaw at large, did it?
No, that's right. And so that's
how would it moot it at all?
Well, that's sort of in our views that it's not
your
just
view. That's just a matter of fact.
Yeah.
The law, the VVRA does not outlaw at large at all. It
Right.
says if you have a residential requirement, but doesn't have, that's not required.
Yeah, and in our view, it is once the city actually took the affirmative step to comply with the broader requirements under the Virginia Rights Act, which was when they submitted the map for pre-clearance to the Virginia Attorney General, and then the Virginia Attorney General granted pre-clearance in part because of the three opportunity districts. To us, that is when the appeal became moot. The plaintiffs in this case are not asking for the 10-1 remedial map. What the plaintiffs in this case are asking for is the removal of the vote dilution that is happening in the city of Virginia Beach. Because of a separate statutory regime under the Virginia Voting Rights Act, the city no longer has the authority and capacity to return back to a system that continues to dilute the minority community's voting strength, regardless of what happens with the Section 2 component. And so because of that, the city's appeal is moot because they can no longer revert to a system that continues to dilute the minority community's voting strength.
I guess I'm not, so it's your position that once this plan has been, the district court's remedial plan has been pre-cleared under the Virginia Voting Rights Act, we have to assume for mootness purposes that the city prevails on appeal. So you're saying even if we said the district court order was wrong, it's reversed, the city would not be authorized to bring a new plan before the state under the Virginia Voting Rights Act. It couldn't try again to get a new plan approved.
It's not, the city may be able to submit a new plan, but the plan that the city could submit would still have to give the minority community at least 3 opportunities to elect the candidates of their choice. And that's because the Attorney General included the 3 opportunities to elect component in his letter granting pre-clearance.
Well, maybe that will be this plan. It'll have 7 single-member districts. And as your colleague said, we don't know. Maybe 3 of those will be opportunity districts.
Well, for the plan that the city is referring to, we do know that that 7 residential district plan would not remedy the violation. That's because the city submitted a 7 residential district plan to the special master in this case. And the special master described that residential district plan as being wholly insufficient in remedying the violation in the remedy phase. And then in the final order, the district court adopted the special master's conclusions in this case.
But we don't know what plan the city would submit. I guess it just seems very hypothetical. What if the city submitted a plan that it could get pre-cleared, but was still different from the district court one?
Well, Your Honor, I think
Or what if, are we 100% sure? Is it 100% a done deal that the state couldn't say, look, now that the Fourth Circuit has reversed the district court order, we think the baseline for considering the non-retrogression principle is the original plan, not the district court's remedial plan. And so long as it's better than that, we'll take it.
Well, Your Honor, it's not clear that there is an original plan in this case, right? HB 2198 removed the original system that the city was using in this case. And so what we have here is what we have here in terms of, as far as the state is concerned, the original plan in this case is the remedial map. And if we're going from the remedial map, the state has said you can use this map to elect city council members in part because it includes 3 opportunities for the minority.
Why wasn't it mooted before the remedial plan was put in place because of the new statute that I thought I just heard you say provided a new electoral structure?
Well, the statute, as we argue in our briefing, the statute itself doesn't moot this case, and that is because the statute doesn't dictate how the lines are drawn.
Well, I'm looking at your demand for relief in your amended complaint at JA 61. Which of those demands did the change in the Virginia law not satisfy or not moot?
Well, it doesn't implement a system that doesn't dilute the minority community's voting strength. And it doesn't guarantee that the minority community's voting strength would not be diluted, which is the issue. The plaintiffs in this case weren't just asking for the removal of the old system.
Right. So is that A, B, C, D, E, or F in your demand for relief?
I don't have the complaint in front of me, Your Honor, but I think ultimately because the plaintiffs aren't just asking for the removal of the old system, we're also asking for the implementation of a system that does not dilute the minority community's voting strength.
But you don't get the implementation of a remedial plan until there's been a violation. And so what I understand the city's argument to be is the district court held what I'll just call the original plan, the 10 at-large seats, 7 of which had residential requirements. That dilutes votes impermissibly under Section 2. But what we don't know is whether the new plan dilutes votes impermissibly under Section 2. And I think there really are questions about that. One of the things the district court relied on, it wasn't just that these were at-large seats, it's that they were 7 of them were at-large residential seats. And the district court thought that was particularly problematic in a way that an actual at-large seat would not be. We don't have any of those anymore. We have these 7 single member districts. We don't know exactly what those will produce. We don't even know exactly what the lines are yet. So it does seem hard to me to say that the district court's ruling as to the old plan kind of necessarily transfers onto this new one and calls this one impermissible also.
Well, Your Honor, the reason I think the reason why we're calling it impermissible is because, again, in the remedial phase, the city submitted at least one 7 residential district plan, and the special master in that case at that point in time found that 7 residential district plan to be insufficient into remedying the violation. I can continue to talk about mootness, but I'm also happy to move on to standing or the merits in this case. As it relates to standing, I agree with both the questions that Judge Harris and Judge Gregory were asking in terms of the racial purity test requirements that the city appears to be imposing here. And that's quite simply because the city is misstating what the plaintiffs are alleging in this case. What plaintiffs are alleging for standing purposes is that they're members of a cohesive minority community whose voting strength is being diluted. They're bringing this claim on behalf of themselves as members of this cohesive minority community. The city makes this argument repeatedly that a coalition claim requires a coalition of plaintiffs. They say this sentence almost explicitly on page 5 of their reply brief, but notably, they don't have a citation for that. And that's for a good reason. No court has ever held that a coalition claim requires a coalition of plaintiffs. On the other hand, district courts, for example, such as the Kumar case, has noted that an individual plaintiff in a coalition claim, an individual plaintiff may bring a coalition claim, and then they must, of course, prove that they're members of this cohesive minority community and that this minority community is.
What's your response to opposing counsel's argument that plaintiffs are litigating rights for others who aren't a part of the lawsuit?
Well, I think they're just simply wrong about that, right? And this goes to when they're bringing this third-party standing argument. You know, some of the cases that they cite, for example, I think it's the Nordgren case, which is a Jewish white woman was bringing claims on behalf of Black attorneys, I think in Mississippi. That's not the case here. The plaintiffs in this case are suffering the same statutory harm as the Hispanic and Asian members of the Virginia Beach community. And that's just simply the problem here, is that everyone is suffering, although the entire minority community is suffering the same harm here. Turning to the sort of merits question as to whether or not Section 2 recognizes coalition claims, the majority of circuits have recognized this. The Supreme Court has said in multiple cases that civil rights statutes such as Section 2 should be read broadly. And reading this broadly here, a class of citizens protected by subsection A simply means that the class has to be a minority group of Hispanic, Black, whether or not do this was formers being thrown around.
Quantitative, that's the coalition, there was cohesion.
Your Honor, what Dr. Spencer and voters want precinct increases. And this is kind of one of the important issues here is that, of the minority community, which is about 38% of the city of Virginia Beach, Black voters are composed about 53% of that number. But that's not necessarily the allocation of the minority community in each of the precincts that the experts are looking at. And so, if we're seeing, as Dr. Spencer says, if we're seeing the increased support as the population increases, then it's reasonable to infer that the Hispanic and Asian communities are supporting the same candidates as the Black voters. There's one other thing that I sort of want to point out here is that the parties also engaged in exhaustive briefing during the remedial phase. Throughout the briefings in this case, before this court, the city doesn't cite the remedial briefings at all. And the reason for that is because the remedial proceedings actually demonstrates that the minority community continues, that the Hispanic and Asian voters continue to vote in concert with the Black voters. And you can look at Dr. Spencer discusses this in the record at SJA 171 to 173. And, you know, even if we turn to the qualitative evidence in this case, the district court looked at as the Fifth Circuit said, one of the ways to use qualitative evidence to determine if the minority community is politically cohesive is by looking at the common social, political, economic, and social bonds. The district court spends about 20 pages discussing all of this history that the minority community engages in the city of Virginia Beach. The city, on the other hand, tries to, and I think this is a good example of the problem, quite frankly, with their entire argument, which is that they take cherry-picked evidence and apply it to a narrow interpretation of the law, where they say, well, no, qualitative evidence must demonstrate voting patterns. The Fifth Circuit hasn't held that. Multiple courts haven't held that. I believe it was this court in the Levy panel held that another way to show political cohesion was demonstrating common aims and using having common aims and using or having common goals and using common aims to achieve them. And so, looking at the evidence in this case from the fighting for single-member districts, the minority community advocated together in protest when city officials made derogatory remarks about Asian members of the community. They have protested against Confederate monuments in the city of Virginia Beach. That demonstrates that the minority community is politically cohesive. But even if we use the city's narrow interpretation of what qualitative evidence can demonstrate voting patterns, I think there are two key facts here. The city presented two witnesses, a Hispanic American by the name of Mr. Benito Loyola and a Filipino American by the name of Mr. Noni Abrahanyo. Both of them testified that Mr. Abrahanyo, for example, testified that the Filipino American community supported the 2018 candidates that Dr. Spencer found to be the minority preferred candidates. And Mr. Benito Loyola testified that the minority community was cohesive in his experience. And you can see those sites at JA 0811. And you can see Mr. Loyola's site at JA 0811. And you can see Mr. Abrahanyo's site at JA 0871. But even if we put the cities of these two witnesses aside, the city itself recognizes that the minority community is politically cohesive. And we know this because in the 2011 cycle, the city tried and failed, might I add, tried to create a majority minority district composed of Hispanic, Black, and Asian voters. And so looking at all of this evidence holistically, which is what Jingles requires and which is the requirement for the district court, looking at all of this, the district court did not clearly err in finding that the minority community was politically cohesive. I'm also happy to talk about Jingles 3, or if there are other questions, if the panel has other questions, but otherwise I'm happy to cede the rest of my time.
Thank you, Mr. Lamar.
Sorry, for the foregoing reasons, for the foregoing reasons as discussed today and in our brief, this appeal is moot. Alternatively, this district court's order should be affirmed. Thank you.
Thank you. Riley?
A few rebuttal points, beginning with mootness. It is absolutely not true that the plaintiffs have abandoned their reliance on HB 2198. On page 2 of our reply brief, it says the case, quote, is moot because HB 2198 forbids the city from using the at-large system. Mr. Lamar also said that the Virginia Voting Rights Act doesn't prohibit at-large voting. That is correct, but HB 2198 does. That's the statute that moots this case. Mr. Lamar also said that—
So what do you mean by HB? I'm sorry, I can never remember the number, HB whatever, prohibits at-large voting. I thought there still was going to be at-large voting for 3 seats.
Correct. For the 7 residency districts, they have to be used as single-member districts. There's no possibility of going back. Your Honor asked about whether the circumstances related to this case. There's certainly no evidence on the record of that. I certainly understand that there were at least some members of the city council who did not want that change. It's not some coordination with the General Assembly. There's no evidence like that. I'm quite confident that did not happen. This is like the Catawba River case. And that leads me to the question of vacatur. As Judge Harris suggested, it would be the case that the outcomes would be the same in terms of vacatur. The rule is that if the appeal does become moot, vacatur is the proper remedy unless the defendant is responsible for that. But in the Catawba River case, this court made very clear, and relying on other cases like the Valero terrestrial case, that where the state legislature does it, another entity of the state is not deemed the same party for.
But does this perhaps lead to a supremacy clause type problems in the sense that, aren't you saying that the state could preempt federal law? Because I don't know, the whole thing about the purpose of the 1965 Voting Rights Act was required and necessary because of what states were doing. And here you're saying that a federal court comes down with that finding of discriminatory plan, going through the process, drawing up a plan. Now, because the state has a statute that moots this, because if it's moot, then that would follow that it's vacated because case law says you're not voluntarily doing it. You came kicking and screaming when you submitted this plan. You agree with that, don't you?
Yes, Your Honor.
Right, you would. It was a shotgun waiting, if you will, when you came to the table. And you likewise can go back, when you go back and change different, it's nothing that prohibits you from getting rid of residency completely and have totally at large.
That is not correct.
What will prohibit you?
The state law.
So you can't, the state law says,
yes.
I thought the state law says if you have a residency requirement, yeah, if you do.
And state law also says the city of Virginia Beach has to have a residency requirement. There is no option.
Virginia Beach, because of what? Because of the charter? Because of the charter?
Yes.
Well, I know you got the Dillon rule that you can't propose to have that changed. General Sims says we know change, and the executive and the legislative, that changes as elections changes.
This court addressed that.
But the right for people to vote without discrimination should not change in this country, correct?
I agree with that.
You agree with that?
I also agree that the right under the Second Amendment shouldn't either, but the U.S. Supreme Court in the New York State rifle case said that a challenge to a state gun law under the Constitution, the Second Amendment, was moot because of a change in the law enacted by the state legislature of New York. And in fact, in that case, the dissent believed that was part of the purpose of the statute, was to moot the case. And the Supreme Court said, that doesn't matter. They've got to bring their claim against the new plan. And that's the same case. The Section 2 doesn't go away.
But the big difference is the Second Amendment is quite different than the purpose of the 1965 Voting Rights Act. The Voting Rights Act was that, just clearly, Black people were just discriminated and they were disenfranchised systematically.
I'm aware of no authority that says the Article 3 jurisdiction of the federal courts turns on the nature of the substantive claim. The analysis could involve a look into whether there is bad faith. There's nothing like that here in this case, and it is moot. I see that my time is out. We would respectfully ask the court to vacate or reverse. Thank you.
Thank you, counsel. We would love to come down and shake your hands, but we're still under protocol for COVID, and we can't do that. But nonetheless, we appreciate your arguments. Thank you for being here today. We appreciate it. Hope that you all be safe and stay well.
Thank you.
Thank you.
Thank you.
Please take your microphone close.
The third case. So this is the third case. We're doing the third. I got you.
I think.
Yeah.
When you're ready, Mr. Carson.
Yes, Your Honor. Good morning.
Morning.
Chief Justice Gregory, Judge Thacker, Chief Judge Gregory, Judge Thacker, Judge Harris. I'm John Corson from the Wake Forest Appellate Advocacy Clinic. Under Local Rule 46A, it's my pleasure to introduce the two student counsel who are here today. First, Chelsea Phelps, who will address the procedural issues, and Jacqueline Winters, who will address the merits issue. Thank you very much.
Thank you. Ms. Phelps?
May it please the court. My name is Chelsea Phelps, and I represent appellate Mr. Brown in this matter before the court today. This court should reach the merits of Mr. Brown's ex post facto claim because the Virginia Supreme Court's application of the statute of limitations procedural ground in Mr. Brown's case was not adequate, and thereafter his filing was in fact timely. Both of Mr. Brown's petitions were filed within the applicable one-year statute of limitations. His ex post facto claim that my co-counsel will discuss accrued when the Virginia Parole Board revoked his mandatory parole and more than 23 years of good time credit in August of 2015. His state petition was filed less than 1 year later in compliance with Virginia Code, which states a right of action shall be deemed to accrue from the date the injury is sustained. In Mr. Brown's case, that injury was sustained August of 2015, the date of parole revocation and loss of good time credit. Before August 3rd of 2015, Mr. Brown faced only the possibility of that revocation and loss. And with their dismissal, the Virginia Supreme Court required him to be cognizant of a harm that had not yet occurred. The ground on which the Virginia Supreme Court's order was based is not an adequate and independent state procedural ground. Because procedural default is an affirmative defense, according to Woodfolk v. Maynard, a decision in 2017 by this court, the state bears the burden to establish the adequacy of a state procedural rule, a burden that has not been met by the state in this case. Because the Virginia Supreme Court's accrual finding based on the statute of limitations procedural rule.
Aren't you asking us to question the state court's application of its own statute of limitations?
Your Honor, we ask instead that the rule on which the decision was based is not adequate, not that their application was incorrect.
And why is it not adequate?
Your Honor, according to Walker v. Martin, a 2011 Supreme Court case, to be adequate, a state law ground must be both firmly established and regularly followed. In Mr. Brown's case, we focus on the regularly followed piece of that requirement. In that same case, the court stated that if applied infrequently, unexpectedly, or freakishly, a state procedural ground may discriminate against the federal rights asserted and therefore be inadequate.
And which one are you saying this was? Freakish?
We focus on freakish and the unexpected or infrequency of the application. In regards to infrequency, according to Woodfolk v. Maynard, a 2017 case decided by this court, to determine consistency, the inquiry is into cases that are procedurally analogous. Mr. Brown relies on the most procedurally analogous case available to him, a case to which the state of Virginia had no reply in their brief. The case on which Mr. Brown relies is the 2012 Virginia Supreme Court case decision, Booker versus Director of Department of Corrections. That case states that the cause of action accrued when the circuit court entered an order revoking a previously suspended sentence and resuspending all but 6 years to be served concurrently. This case stands in contrast to Mr. Brown's case, in which the state found the action to have accrued before the Virginia Parole Board's order was entered in 2015, stating instead that his claim accrued in October of 2013 when he was released on parole. With this single non-procedurally analogous case, the Virginia Supreme Court's accrual finding is unexpected or freakish. The freakish component comes from that expectation for Mr. Brown to have filed a claim in 2013 based on a harm that did not happen until 2015.
How freakish can it be? The district court sort of came to the same conclusion. The federal district court also thought that this claim accrued in 2013. And I understand your arguments for why that doesn't seem on its face to be sensible. But that's what the district court thought. That's what the state court thought. It's not that freakish. I mean, or how can it be so freakish if an entire Supreme Court and then the district court all came to the same conclusion?
Your Honor, there is a bit of ambiguity in the Virginia Supreme Court order as to which specific claims they state accrued in 2013. I think the district court does tease things out a little bit more clearly.
Well, are you suggesting that I took from the first part of your argument that you believe that the Virginia Supreme Court found the ex post facto claim untimely and that was freakish? But now you're suggesting maybe the Virginia Supreme Court did not make that finding?
The Virginia Supreme Court, based on what we can find in the order, seems to consider Mr. Brown's claims all as one, all together, instead of
untimely.
And then thereby finding that his petition was untimely, individually considering the ex post facto claim that we'll bring forth today. And then the district court, hopefully this will clear it up a little bit. So the district court, in considering a Supreme Court finding based in Pace v. DiGuglielmo, a 2005 Supreme Court decision, when there are multiple habeas claims, should consider the statute of limitations on a claim-by-claim basis. I think that's something that the district court failed to do. In fact, even changing some of Mr. Brown's words, saying he was cognizant of the change in law at a time he wasn't.
Can I think I didn't frame my question right. Let me just ask you this. Is your reading of the Virginia Supreme Court order, which is short,
Yes.
that the Supreme Court of Virginia thought that the ex post facto claim was untimely?
It's unclear, I think, to us what exactly or which claims they refer to in that order. Because it is so brief, it's hard to tie any individual claim back to their language in the order.
Okay, so I do think you start to raise this as a suggestion in your reply brief, although not your opening brief. But so you don't really have an answer to the question of what the Virginia Supreme Court did here.
Yes, that's correct, Your Honor. It does seem quite vague based on their Supreme Court order entering the dismissal for Mr. Brown.
Okay.
Mr. Brown's federal filing was in fact timely. considering that the state ground is inadequate. His federal claim was told and ultimately filed less than 1 year after his state habeas petition was denied by the Virginia Supreme Court in accordance with the U.S. Code 2244. In summation, Mr. Brown asked that the merits of his ex post facto claim be heard here today because the Virginia Supreme Court's basis for untimeliness is not an adequate state procedural ground, and his claim is therefore timely. Thank you, Your Honors.
Thank you, Ms. Phelps. Mr. Gallagher? I'm sorry, I'm reading it wrong. Ms. Winters.
May it please the court. My name is Jacqueline Winters, and I also represent the appellant in this action, Demerick Brown. The issue in this case is whether Virginia's assertion of authority to resurrect completed sentences by revoking the time credit that extinguished them violates the ex post facto clause. Demerick Brown completed serving a series of sentences for offenses he committed in the 1980s through a combination of both incarceration and earned good time credit. While he was serving his final sentence, Virginia revoked his mandatory parole and further punished him by revoking his good time credit. All of the good time credit that extinguished his prior sentences was resurrected, redefining his time served from complete to incomplete. This revocation, which occurred pursuant to a Virginia statute amended and a parole board policy applied after Mr. Brown's sentences, increased the measure of punishment attached to his crimes in violation of the ex post facto clause. Your Honors, the version of Virginia Code section 53.1 in effect at the time of Mr. Brown's convictions. Under that version of the code, every inmate was to be released 6 months prior to the date of his final release. However, in 1994, the Virginia General Assembly amended that statute, stating that final discharge may be extended to require the prisoner to serve the full term imposed by the sentencing court that was unexpired at the time of parole. It further defined final discharge to disregard good conduct credit. Subsequently, in 1995, the Virginia Parole Board adopted a parole board policy that largely mirrored the statute of this language. It changed may to shall and was explicitly adopted pursuant to its authority under the new code 53.1 section 159. The effect of this statutory amendment and the new parole board policy was that the parole board would require prisoners who had previously completed sentences with the aid of good time credit to serve time that previously would have been considered completed under the old policy.
Right. And what would you have us do with our 2000 case of Warren versus Baskerville, which seems to go directly against your position?
Your Honor, Warren is distinguishable for three primary reasons. Although there are facial similarities between the Warren case and Mr. Brown's case, the two are categorically different. First, the inmate in Warren was serving 1 8-year sentence, and he was challenging revocation of good time that occurred on an ongoing sentence. Here, Mr. Brown is challenging the revocation of good time credit on sentences that under the old law would have been deemed completed and extinguished under that old law. And the import of this change was recognized by the Eastern District of Virginia in 1999 in Woodley versus Department of Corrections. It recognized that for prisoners serving consecutive sentences, the 1995 change in the parole board policy and 94 change in the law meant that sentences that were would have been considered fully served were not served in the eyes of the law.
But counsel, I do understand how that distinction makes this particularly unfortunate for your client. I mean, it exacerbates the effect for your client, but I don't see how it addresses sort of the reasoning in Warren, which was that it really doesn't matter how this plays out because it's not the result of a legislative change. It's just an administrative change in policy, and that's just entirely outside the ex post facto clause.
Your Honor, that's another point that makes this case distinguishable is that in Pew versus United States from the Supreme Court in 2013, the court foreclosed the categorical distinction.
You think that under current Supreme Court law, changes in administrative enforcement policies like this one now trigger ex post facto clause?
Yes, Your Honor.
Inquiries?
Yes, Your Honor. In Pew versus United States, the Supreme Court was unpersuaded by the government's argument that U.S. sentencing guidelines lacked the sufficient legal effect to implement.
But that's a different question. The question in that case was, when is a discretionary policy treated as though it has the force of law for purposes of the ex post facto clause? But it wasn't a question about where did this change come from. Did it come legislatively? Did it come from a legislative delegation of rulemaking authority, in which case the ex post facto clause applies? Or was it just an administrative change in enforcement, in which case it just doesn't apply? And that's what we held in Warren.
Your Honor, the court in Pew also stated that the presence of discretion does not displace the protections of the ex post facto.
But that is a different question. The discretion, it doesn't matter. Sorry, I don't want to cut you off.
The court, I would also like to point the court to United States versus Lewis from this court in 2010, in which this court similarly rejected the argument that the ex post facto clause applies only to laws that bind rather than revise, holding that application of sentence guidelines implicating sentences in effect at the time of sentencing rather than guidelines in effect at the time of offenses did in fact implicate and violate the ex post facto clause.
So I guess what the question, let me try to frame this right. This policy, the new Virginia policy, let's say it's entirely mandatory. I think it is, right? It's a mandatory policy. If your parole is revoked, we're going to make you serve all of your time as though you never had these good time credits. It is mandatory, right?
It was discretionary, but the discretion did not exist prior to the change in the 1994 law. So the statutory language said prisoners may be required.
Right, but the policy.
Yes, the policy did say shall.
Right, so the policy is mandatory. And I think that just sort of takes us out of Lewis and the guidelines. Those cases were about what do you do with a policy that's not mandatory, like a non-mandatory sentencing guideline. This policy is mandatory. So it doesn't seem to me that those cases really bear on it. The problem with this policy, from your perspective, is not that it's discretionary, it's that it was not the product of a legislative change. Can you address that?
Yes, Your Honor. The issue with the policy, whether it was discretionary or mandatory, was that at the time of Mr. Brown's offenses and at the time of his sentencing, the law that changed the way that consecutive sentences were imposed and deemed completed changed. And so that is why, as applied to Brown, using the standard from Garner versus Jones from the Supreme Court, as applied to Brown, the question is whether retroactive application of the amended policy, as applied to him through practical implementation, had the sufficient risk of increasing the measure of punishment attached to his crimes. And that's why the court needs to look at these circumstances as they were applied to Brown. The retroactive application of both the statutory change and the amended policy, whether mandatory or discretionary, was not in effect at the time of his sentencing. And under the old law, the sentences that he had served and completed under the old law would have been deemed completed and expired. Another way to put this is if Mr. Brown had finished serving a sentence and he was let out of jail, not on parole, but he had finished completing his sentence and he was let out from the prison, there was a day in between the day in which he was let out and completed a new crime, there would be no question that the good time credit that he had earned on that first sentence that had allowed him to get out of jail would have any effect on the sentence imposed or the time that he had to serve on that next crime that he committed. And so just logically, it doesn't make sense that the Virginia Parole Board, because his sentences were under Virginia law, they're required to be treated consecutively. It doesn't make sense that because of the timing of his sentences and crimes, that they would have been considered one giant sentence that was capable of being resurrected and having those 23 years of good time he had earned tacked on to that sentence. Your Honor, I see my time has expired. May I briefly conclude?
Yes, you may.
For the reasons stated, we respectfully request this court find that Mr. Brown is entitled to habeas relief. Thank you.
Thank you, Ms. Winters. Mr. Gallagher?
Good morning, Your Honors, and may it please the court. I am Kevin Gallagher, Deputy Solicitor General of the Commonwealth of Virginia, representing respondents Karen Brown, Harold Clark, and Wendy Brown. With me today is Jordan Minot, Assistant Solicitor General. This case is a straightforward AEDPA statute of limitations case. The Supreme Court of Virginia held that Mr. Brown's state court habeas petition was not timely filed. Because the petition was not timely filed, Mr. Brown is not entitled to statutory tolling under AEDPA. Without statutory tolling, Mr. Brown's petition was untimely under the statute of the limitations for AEDPA, and the district court's dismissal was proper.
Counsel, can I ask you a question? It sounded from the district court opinion that you read the Virginia Supreme Court opinion order, the Virginia Supreme Court order differently in front of the district court and suggested that actually the Virginia Supreme Court had not dismissed the ex post facto claim about the good time credits on timeliness grounds.
Your Honor, the petition is very clear as to what it says. Or sorry,
Is that the position you took in the district court? Did the district court misunderstand what you were arguing there?
I think the district court held that
I know what the district court held, but the district court said that you argued that this was not done on timeliness grounds. And so I'm asking, have you changed your mind? What happened here?
No, Your Honor, I don't believe that we've changed our mind. I think that we have held from the beginning that the Virginia Supreme Court order is very clear.
So the district court misunderstood your position.
I think that's right. And you can see that in the footnote that is in the district court's opinion, which says that regardless of whether of what the Virginia Supreme Court held and how the ruling went forward, that is in fact that the petition was untimely. And so what we're saying here.
So you did not in fact argue that, and I'm quoting, argued that the Supreme Court of Virginia only dismissed some of petitioner's claims as untimely because the court provided an alternative holding regarding claims that concern good conduct credit and discretionary parole.
Your Honor, I believe that there are two sets of claims that.
I mean, it's no big deal if you change your mind, but you want to stick to the idea that the district court misunderstood your argument.
Your Honor, I would have to go back and look at the briefs, but what I'm telling you today is very clear that the Supreme Court of Virginia ruled that the entire petition was untimely. So in order to be timely filed, Mr. Brown had to submit his federal habeas petition within 1 year from the date that the cause of action could have been discovered. And under any theory of the case here, whether it was October of 2013 or August of 2015, that claim needed to be filed in federal court in August of 2016.
How could he have discovered it in his claim in October 2013?
Your
when
Honor,
he was out on parole and his good time credit had not been taken away from him yet, as far as he was aware.
Yes, Your Honor. I have two responses to that. My first response is the claims that were actually made in the petition. If you look at the state court petition that Mr. Brown submitted to the state court, his counsel has very ably made it seem as if there is an ex post facto claim that was brought specifically about the revocation. But I would give you a cite to their brief on page 9 that characterizes the claims that are in the state court petition. They say that maybe
we should just look at the petition rather than characterizing what the petition says.
So I would invite you to do so, Your Honor. On pages 312, pages 312 and 313 of the joint appendix is the claim that counsel points to as far as what is the ex post facto claim that is still at issue in this case. Now, keep in mind that Mr. Brown brought somewhere between 8 and 10 claims. As the district court mentions, they're somewhat overlapping and repetitive. But what Mr. Brown's counsel points to is what's claim B in the state court petition as the ex post facto claim that is still at issue. In footnote 1 of page 9 of their brief, they say there's due process claims, there's double jeopardy claims. None of those are at issue. So what is at issue, according to them, is claim B in the state court petition. Claim B is an ex post facto claim about the mandatory release in October of 2013. He is claiming that he should have been released with only 6 months probation, but he was actually released with 3 years probation. And that is the ex post facto, the application of that policy is the ex post facto claim that he makes in Claim B. So,
you're saying not the revocation of his 23 years of good time
correct,
credit.
Your Honor. In Claim B, that's correct.
Well, if that's right, counsel, then the Virginia Supreme Court did not dismiss this claim on timeliness grounds. There may be a different procedural problem here, but that's not it.
Your Honor, I do believe that the Virginia Supreme Court dismissed this on timeliness grounds.
Well, it didn't dismiss the claim in question on timeliness grounds. You're telling me now he never raised that claim. So how could the Virginia Supreme Court have dismissed it on timeliness grounds?
I want to make sure I'm understanding your question. Are you saying the claim that is in the brief about the revocation of the 20?
Yes, you do not believe that claim was dismissed on timeliness grounds.
I don't believe that claim was raised. If it was raised at all in the petition, both the state court and the federal district court looked at that petition and said that the claims accrued in October of 2013. And Your Honor, the point of my argument here is it actually does not matter whether the claims accrued in October of 2013 or August of 2015. Under either trigger date, the petition was untimely because he had 1 year from August of 2015 in order to file a federal habeas corpus petition. He did not file until December of 2016. Therefore, the only way that his petition would have been timely is if it was tolled for some reason. The only argument that Mr. Brown has ever made about tolling is statutory tolling under the AEDPA statute of limitations provision in section 2244D2. In that section, it says that a federal petition is tolled while a properly filed state court petition is pending. Mr. Brown's state court petition was never properly filed because the state court held that the petition, the entire petition, not some subset of the claims, but the entire petition, the language is clear, that petition was dismissed on timeliness grounds. Because it was dismissed on timeliness grounds, then it was not properly filed under federal precedents. And I would point you to the Pace case from the United States Supreme Court in 2005.
And was part of that entire petition that was dismissed his complaint about this 23 years being taken away from him?
Your Honor, there are references to the 23 years being taken away.
Okay, so yes. So then I go back to my original question. How would he have known about that in October of 2013?
Yes, Your Honor. He would not have known about that specific set of facts in 2013. But what I'm saying is that regardless of whether we think that the state court was right or wrong, or Mr. Brown thinks that the state court was right or wrong, the state court dismissed the entire petition as untimely. And that is, as the Supreme Court said in Pace, the end of the matter.
No, it's not the end.
No, you go ahead.
It's not the end of the matter because we have to look at whether or not there was an adequate remedy available for and meaningful. And you have to parse this out because you're conceding that after it was revoked and his 23 years were imposed on him, his good time, then he did file, right? Because after it was revoked in 2018, right?
In 2015.
I mean, it was revoked, right?
Yes, in 2015.
All right. So then when he filed it in the court, that was within the year, was it, when he filed that?
He filed a federal habeas petition in December of 2016. So it was actually not within a year of August of 2015. That's exactly my point, Your Honor. So
when did they actually assess the 23 years on?
In August of 2015, Your Honor.
Right. August 2015.
Yes, Your Honor. So in order for his federal petition to be timely, it needed to be filed in August of 2016. However, he did not file it until December of 2016. So it was several months late. And the only reason that he says that his petition is timely is because of the tolling that he says he should get under section 2244D2, which tolls when a properly filed state petition is pending in the state court. However, the state court, the Virginia Supreme Court, held that the petition was not properly filed. It held that the entire petition was untimely. Therefore, he doesn't get the tolling in that is under 2244D. And Your Honor, I want to make sure very clear there's two separate analyses here. There is the analysis of the federal statute of limitations under AEDPA, and then there's a separate analysis of the procedural default rules. That analysis looks at the procedural default analysis, looks at whether there are adequate and independent state law grounds, looks at whether it's cause or prejudice, looks at manifest injustice. The federal EDPA statute of limitations does not do that analysis. Basically, as long as the state court, the Supreme Court has been very clear, as long as the state court held that the petition was untimely, it was not properly filed, and as the Pace case says, that is the end of the matter. This is, there's not an analysis of cause and prejudice. There's not an analysis of adequate and independence. It's just the end of the matter. And I would point.
There's no analysis of manifest injustice?
No, Your Honor. There are, for state procedural default analysis, there would be. And we've made those arguments in the brief and we would stand by it. However, for the separate question of whether it was timely under the federal EDPA statute of limitations, the courts have been very clear. And I would like to.
But I guess I think what picks up the slack, I take your point, but I think what picks up the slack is equitable tolling under EDPA, right? That's where you would put the same bucket of concerns about manifest injustice and things like that.
Yes, Your Honor. Equitable tolling does exist. However, there's two reasons why it should not be applied. First is that Mr. Brown's never raised equitable tolling below. He didn't raise it in his opening brief, didn't raise it in his reply brief. This court's case in United States v. Bowman made clear that equitable tolling can be waived as any other argument. Number two is the Supreme Court has been very clear. I'd point you to Holland v. Florida, and then this court's en banc decision in Whiteside made very clear that equitable tolling should only be in rare instances and extraordinary circumstances. Mr. Brown has not shown extraordinary circumstances or rare instances. He hasn't even made an argument that would fit into that category.
Well, I kind of feel like maybe the argument would be if, in fact, the Virginia Supreme Court held that this claim that did not exist until 2015, that the statute of limitations started running in 2013, like that would be sufficiently unpredictable. I mean, I don't want to use freakish because that's sort of the term of art on the other side, but that would have been so hard to predict that he could have reasonably relied on the fact that this was a timely petition in the Virginia Supreme Court. Turns out he was wrong, but he could have reasonably relied on that tolling period.
Understood, Your Honor. The Supreme Court addressed this exact situation in the Pace case, and I would direct your attention to that. The Supreme Court said that in situations where a petitioner in state court believes that their petition, for whatever reason, could be untimely or have some sort of concern, they should file a federal protective petition in federal court. This is a regularly followed procedural mechanism that petitioners frequently do, and Mr. Brown has brought several federal lawsuits, and so he certainly knew how to do so.
Can I ask you just back up for a minute and ask this question? I find the procedural part of this case very, very tricky. It seems to me you have a pretty good merits argument under Warren. Why lead with the procedural part?
Your Honor, EDPA has been put into effect in this Commonwealth and this country in order to protect situations exactly like this. There are certain hoops that people need to be able to jump through because otherwise we would just have a multiplicity of lawsuits.
It's not jurisdictional or anything. There's no reason why a review in court couldn't go to the merits first if that were more straightforward, right?
Completely understand, Your Honor, and I'm happy to turn to the merits.
No, that's okay. But your argument is you think as a matter of principle, it's important to enforce.
Yes, Your Honor. I think that the Commonwealth has an interest in making sure that these statute of limitations are enforced. And certainly my clients, the respondents, do as well. But turning to the merits, Your Honor, I would point out that I think, as some of the questions suggested, there certainly is the very clear fact that Mr. Brown's claim is entirely foreclosed by this court's decision in Warren v. Baskerville. So in that case, the court has made clear that the ex post facto clause, by its terms, only applies to laws. So in this situation, we have not a law, but the use of discretion subject to a certain law. Mr. Brown makes several arguments in his brief as to why, and here an argument as to why there should be a distinction between the case in Warren v. Baskerville and this case here. However, some of them are factual, which really doesn't go to the actual legal issue here. And other ones are just about the fact that the Supreme Court has changed the law over the intervening 22 years. I would suggest that the law has not changed at all. The cases that Mr. Brown's counsel cites are, for instance, United States v. Lewis from this court, and in the Pew case in the United States Supreme Court are about sentencing guidelines cases, which are sort of a completely different beast. In fact, this court's case in Burnett v. Fahey from 2012 makes very clear that there's a unique role of the sentencing guidelines that sort of suggest that specifically for that case, distinguished United States v. Lewis, and I think for the same reason would distinguish the Pew case, which came 1 year after, so was not addressed in the Burnett v. Fahey case. But Mr. Brown, in his brief, does make a couple arguments as to why Warren should be distinguished, and they really don't apply here, right? So in the first case, or the first argument, is that in the actual revocation here, the parole board cited Section 159 of the Virginia Code. However, the Fourth Circuit in the Warren case, this court in the Warren case, said that even though the Section 159 was actually specifically stated in the revocation letter, that actually Section 165 is the relevant section of the Virginia Code. And that's Section 53.1-165. That section, which has existed the entire time Mr. Brown was in prison, has made clear that the parole board always had this discretion. So really what Mr. Brown is disagreeing with is not a change in the law. The law has remained the same. Mr. Brown is disagreeing with a change in the parole board's discretion that is given to it by the law. And in the Burnett v. Fahey case that I mentioned from 2012, this court made clear that when the statutory scope of the discretion doesn't change, then there's actually no ex post facto problem here. And so, Your Honor, unless you have any further questions, we would respectfully request that you.
Let me ask you a little question before you go. What remedy would there be for the Supreme Court if he had timely filed after his good credits were revoked and the sentence 23 years was imposed? What would be the remedy for the Supreme Court of Virginia?
So, Your Honor, just to make sure I understand your question, you're asking if.
Otherwise, you're saying that he did not timely file his petition to the Supreme Court of Virginia, correct?
That's correct.
So that assumes that there's a remedy available that's adequate and meaningful. That's why we give deference, right, on 2254, because it is consistent, it's adequate and meaningful. I'm asking you, what remedy could the Supreme Court of Virginia give him?
Your Honor, I want to make one thing clear just before I answer your question.
You want to change my question?
I'm not going to change your question, actually.
Oh, okay.
So, Your Honor, in Section 2254 is sort of a different analysis. We're not saying the court ruled on any sort of actual substantive grounds. There was a procedural timeliness bar here that then creates the situation in which it's untimely under federal EDPA statute of limitations, and also would create a procedural default. But your question as to what remedy would be available to him, he would file a habeas petition, and then the state court could rule on that petition as far as what claim he made. However, in this situation, he didn't file a timely petition, so there was.
What remedy is available?
He's filed a state habeas court petition.
I know, but there is no remedy, is there? Because you can't name one.
I believe that just like he's asking this court to
could the Supreme Court of Virginia release it?
He is asking for a remedy of saying that the revocation of his good time credits is an ex post facto violation. So I assume what he's asking for.
Constitutional? Is that a constitutional question?
That is how Mr. Brown has characterized his claim. And so if it is in fact a constitutional issue, I assume that the remedy he is asking for is for that good time to be, the good time to be reimposed such that he wouldn't have the extra 23 years in jail. And I would say, Your Honor, this is.
But then the Supreme Court of Virginia would say this is a policy of the prison, so we can't do anything about
it. If you're asking whether I think that this goes to the merits of the strength of the merits of the ex post facto claim, I 100% agree with you. I think that the exact issue is that
he didn't get a say on the merits yet, right? We don't do it in the first instance. The district court didn't do it, did they?
The district court did not rule on the merits.
Well, why should this court rule on the merits in the first instance?
I would invite you not to rule on the merits. I think for that reason, we should be back.
But if there's a constitutional question that there was no adequate remedy or meaningful review in the state court, we don't have to defer to that. So perhaps the ruling might be that this case needs to go back to the district court to consider that. Because, right, if the matter is solely equitable remedy, really, isn't it? The best he could get is a declaratory judgment from the Supreme Court that says we declare it to be a violation or something like that. In this case is particularly rather insidious because the man said, please, I don't want to leave the prison. I only have 7 months to go. Am I right? And they said, no, you better leave here. Matter of fact, we're going to charge you with trespass, and that will be the triggering violation. And so then 23 years, so the sword of Damocles is over his head, and that he earned that 23 years, didn't he? You don't just get that automatically.
Your Honor, I think to be clear, first of all, and I see my time is almost up, may I answer your question? So I think to be clear, Mr. Brown certainly alleges that those things happened when he was released. But from my client's perspective, the Virginia statute on mandatory parole makes it mandatory. He had to be released within 6 months of the end of his date. There's not another sort of option. I mean, that's the way that the statutory scheme works. And Mr. Brown, because
he had finished his sentence, because he was not paroled, he maxed out. That's why it was mandatory, correct?
He was released on mandatory parole. He was released on parole.
Because the combination of actual time served and actual time earned.
Correct.
That was a total, complete sentence. Otherwise, it wouldn't have been mandatory, right?
But to be fair, Your Honor, as part of the way that system works, you are released early. That's sort of the benefit that is given on conditions. And one of the conditions
is what's the early?
You're released 6 months before your end time. And so he's released 6 months early. And as part of that, he's on probation for a time. And then there are certain conditions that he needs to follow. Condition number 1 is don't violate federal or state laws. And within 4 months of being released, Mr. Brown committed grand larceny and ended up back up in the system. And that's why his good time was revoked. Had he been able to end out his term of probation without violating the conditions of parole, especially condition number 1 of don't violate the laws, he would have been able to be out with all that good time accrued. I see my time is up.
And that would have taken him how long? 6 months, you said?
He was on probation for 3 months from the time, or sorry, excuse me, I misspoke, 3 years from the time that he was.
3 years. 3 years.
3 years. And as part of that, as part of the deal, he just had to follow certain conditions, number 1 of which was do not violate the law. And he violated that within 4 months.
Yeah, but that raises potentially all kinds of questions, perhaps constitutional questions in it, rather arbitrary in it. That means no matter what he did, as long as it was a violation of what? Law?
Of federal or state law.
Law, and did it say misdemeanor or felony? It doesn't say, does it? It doesn't say, does it?
Your Honor.
But that means if it doesn't say, it could be a misdemeanor. So if he went into a 7-Eleven and stole a slice of bologna, he gets 23 years?
Your Honor,
isn't that right?
That is, if he is convicted of
There's something unjust about that, isn't it? Isn't that what the federal courts were about to look in terms of state procedures that work to it is?
Release is I will obey all federal, state, and local laws and ordinances. And here, Mr. Brown did not steal a slice of bologna. With due respect, Your Honor.
That doesn't matter what he did particularly here. In terms of, but the effect is, for example, he could spit on the sidewalk on federal veterans hospital grounds, and that would be a violation, right?
If that is a violation of federal law, which I'm not aware of specifically, but if it was, then according to the language here, yes. But Your Honor, the point of we are sort of down the road as to what the actual issue here is, whether this is unjust or unfair. This is the system that he agreed to when he left, and then he violated it 4 months later. Unless you have any further questions.
So you say you can agree to cruel and unusual punishment? I didn't know that.
Your Honor, I would say this is not cruel and unusual.
I know, but you said as if that's the end of it. The fact that he agreed to it. Is that right?
It is not the end of it.
I didn't think so. I didn't. I just want to make sure that point is not the end of it.
Thank you, Your Honor.
All right. Thank you so much, Ms. Gallagher. Ms. Phelps.
May it please the court. I would like to start by first, I think, better answering Judge Harris's question from before I got a little lost. So as we point out in our brief, the Virginia petition does tease out between those claims that were not filed within the October 2013 date, which stands in contrast to petitioner's claims concerning his good conduct credit and discretionary parole procedures, which they said were not cognizable under Carroll v. Johnson, a classification which actually this court in just 2021 in Wall v. Kaiser considered the use of Carroll dismissing habeas petitions apparently misread the decision on which it relied, meaning the Carroll decision itself. I think that's the distinction that we were looking for earlier, and my brain just couldn't get there. And then I would also like to run through the dates for the federal filing. I think there was a bit of confusion about a December 2016 date. In fact, according to US Code 2244, the limitation period runs from the date factual predicate of claim could have been discovered, which in a habeas petition regarding earned good time credits is the time the petitioner discovers the improper denial of credit. Again, that August 2015 date, the dates of Brown's revocation and loss of good time. His state filing in December of 2015 told his federal habeas petition on a ground that was not adequate. However, the petition was told until the Virginia Supreme Court dismissal in May of 2016, at which point the federal statute of limitations did begin to run again. However, Brown timely filed after May of 2016 in January of 2017. Therefore, Mr. Brown does ask his ex post facto claim be heard on the merits by this court. Thank you.
Thank you, counsel. Ms. Winters.
May it please the court. I would like to make 2 points on rebuttal. The first is Burnett versus Fahey, which my opposing counsel mentioned, was decided without the benefit of the Supreme Court's precedent in Pew, suggesting that Warren could be reconciled with the Lewis case from this court in 2010. But the Burnett court relied on the assumption that the Virginia Parole Board had the authority to do what it did in Warren, which was revoke good time credit on an ongoing sentence. But it certainly does not reconcile that with what the Virginia Parole Board did in this case, which was revoke good time credit on sentences that under the old law would have been considered expired and extinguished under that second law. Second, in Pew, the Supreme Court cited Garner versus Jones for the proposition that the touchstone of the inquiry is whether a retroactive change presents a sufficient risk of increasing the measure of punishment attached to the covered crimes. There's no question here that as applied to Mr. Brown, there was a retroactive change in the measure of crimes. And the reasoning that the Warren court relied on was that there was no increase in the original measure of punishment. But that reasoning in light of Mr. Brown's case is not sufficient because under that old law, those sentences would have been considered completed and expired. For the reasons stated, Mr. Brown respectfully requests this court find he is entitled to habeas relief. Thank you.
Thank you, Ms. Winters. I note that your court appointed, and Mr. Corzine, and thank you so much for bringing these demon deacons up here and well acquitted their school's fine reputation as a law school, and we appreciate their fine arguments, and as well, Mr. Gallagher, your able representation of the Commonwealth. We would love to come down and I might say too, court-appointed counsel really do a great service to this court because lawyers like yourselves who bring these cases and defend them, represent them, help us to do this job and get through these very thorny issues. We would love to come down and greet you all, but we cannot do so in our COVID protocol. But know very much that we appreciate your being here and we wish you well and be safe. Thank you so much.
Please take your microphone covers with you.
You may be seated, counsel. Hawkins, when you're ready.
Good morning, Your Honor. Chief Judge Gregory, members of the panel, may it please the court. I'm Richard Hawkins of the Hawkins Law Firm. I'm here this morning on behalf of the appellant and the plaintiff, Regina Webster. We are here in this appeal from a grant of summary judgment from the district court as to the defendant appellee, Chesterfield County School System's motion for summary judgment on Ms. Webster's sexual harassment claim. I think Judge Hudson correctly described the facts of this case as delicate, and I will not repeat them here except where necessary to discuss issues of fact. Where I think the district court went wrong, and I believe it did so dispositively, as to three key legal errors, and they permeate the district court's decision just by way of a preview of sorts. Those issues are that the district court required evidence of intent, sexual intent for purposes of the because of sex requirement for Title VII for a sexual harassment claim. The district court imposed a higher burden of proof or higher burden of evidence for purposes of showing the objective component or the objective prong of the severe and pervasive prong of the sexual harassment claims under Title VII. And then the third error of law that the district court made is that it failed to view the evidence in the light most favorable to Ms. Webster, and it did so throughout its decision. So I'll begin with the first point of law that we believe the district court erred with, and that's the issue of intent. The district court specifically, it didn't say it did this, but it absolutely did this, held that evidence of intent in the context such as this one, and of course, this is a unique context. We are dealing with a special education student who suffers from significant intellectual and mental disabilities. I don't think there is any question that this individual, this child, cannot form the requisite intent if it is so required. But we believe the law does not require that. We believe the law.
Well, it requires it to be based on sex. So how could it be based on sex when the student was incapable of distinguishing between the male and female gender?
We look at what the conduct was, the effect of the conduct. And I think the Christ decision out of the Eighth Circuit provides the best analysis. It says that we look at comparative behavior. Yes, the student could not distinguish, but the student did target females and female staff more so than male staff.
Counsel?
Yes, ma'am.
I don't understand this point, the comparator evidence point. Who's the comparator? Who's the adult male staff member who was not targeted?
Well, there are others. There was Mr. Johnson, who was the vice principal.
But who was in the classroom trying to control, who is the adult male in the classroom trying to control the behavior of this child? That's the comparator. All the expert testimony is that this is very natural behavior for this child. When someone is trying to sort of control his behavior, this is how he defies those efforts. And I don't understand it. It looks like I don't see any references anywhere in the record to another adult male in that classroom.
You will see in the point sheets, and those are the colored sheets with the smiley faces, there are repeated references to a Mr. Johnson. And you will see that, and I don't want to overstate the record. I understand your point very, very correctly, is that within the classroom setting itself on the full day basis, there was no other male who was there for the entire period of time. However, there was a male who repeatedly assisted that room, and you will see repeated references in the record to Mr. Johnson taking the student, he went to go take a walk through the hallway with Mr. Johnson. That is your comparator, and we submit that this is sufficient, viewed in the light most favorable to Ms. Webster, to show that he is a proper comparator. And we didn't identify much more than that. But you will look at Ms. Webster's declaration, and she says that he engaged in behavior that targeted females more so than males.
No, that's not what she said. She says that he inappropriately touched both male and female students. That's the comparator.
Correct.
but he more frequently touched female adults, period. I don't see where she says he more frequently touched female adults than male adults. And I expect that's because there were no male adults in the classroom on a regular basis, which puts her in a tough spot. Understood.
I understand. I would say that's more an artful sentence than it is.
But it's the only thing in the record. It's not as though there's anything else in the record about how often it's done. I mean, that's it. That's what you rely on because that's what's in the record.
That is one piece of the record. We also look at the testimony of Ms. Ellerby. Her deposition testimony made a distinction between male adults and female adults. And we submit that is appropriate. Again, we don't have to identify the specific person involved, although I believe the record reflects that that person would most often be Mr. Johnson. But even if the court were to conclude that Ms. Webster's declaration testimony is not in and of itself sufficient, the deposition testimony from Ms. Ellerby on that point is sufficient to establish a question of fact.
Ms. Ellerby said that that SM touched female adults more often than male adults. She said she wasn't aware of male adult touching. Is that right?
I believe that is what she said.
It's okay. I think it was that, not aware of male adult touching. Yeah.
My point in saying this, and again, I understand the court's concern, but I think the evidence creates the reasonable inference that SM engaged in behavior that was more targeting of males, or I'm sorry, more targeting of females than males. I think it's also—
What does that mean, targeting? I thought you said intent didn't matter, and also that the student could not distinguish between male and female gender. So I still don't understand how you meet the because of sex requirement.
Maybe a poor choice of words, but
because it sounds just like intent.
Well, it's conduct. The conduct affected
to the fact that this student touched a teacher that was a woman.
Correct.
That's it, based on sex. Even though the student could not distinguish between the male and female gender.
I submit the record gives just a little bit more of a picture with regard to the student's behavior as to male adults. But the instances that we are describing here are uniquely targeted towards sexual organs. These are not— I mean, there's abundant evidence in the record that this was a child who had behavioral problems, who spit, who threw things, who was—
So I guess that goes to my other— So if there is a claim at all, before we even get to summary judgment, if there is a claim at all for student, for teacher under title here, then, and this is common behavior for students that have, at least the record indicates and the experts indicate that this is common behavior for students that have intellectual and emotional disabilities, then they are educated where?
They remain educated in the public school system.
Well, if there's a claim, if there's a claim to be made by—
Then we have situations where we have to adapt. We have—
How?
Well, I'll try to—
One in. That doesn't address the problem.
I'll say the word and engage anybody else in the classroom. Yes.
What I think makes this case so difficult, and I think the district court talked about this, is right. Usually in these cases of a hostile work environment based on sex, the question is, did the employer sort of step in and fire the offending employee or cut off the offending customer? But that's not an available option for a school district, because all of these students are entitled to a free public education. They're entitled to be mainstreamed into the classroom. So there's a way more limited kind of range of responses available to the school. And I just don't— I mean, I guess I understand what you're saying, maybe that this particular plaintiff was a particular target, but if the idea is that the presence of this child and children like him in a classroom is going to be enough by itself to create a hostile work environment, I'm just repeating Judge Thacker's question. I'm sorry. What do you want these schools to do?
They are great questions. And Judge Hudson very thoughtfully asked me exactly those questions. And I think the answer is it's multifaceted. The first part is that SM here engaged in, despite the expert testimony about what is or is not expected from a child of these disabilities, he engaged.
I think the appellant agreed with it. Ms. Webster agreed with it. Okay, go ahead.
Well, right. This is the kind of behavior that you see, but his behavior was above the norm. It was beyond the pale.
Was there an expert who said that? Because there were two experts who said, no, it wasn't. Was there an expert who said, yes, it was?
There was not. And we submit that there was not one necessary.
Why not?
Yes.
Why not?
Because the fact of the egregiousness of the conduct is sufficient to allow a reasonable person.
Yeah, but how do you have to, the egregiousness, I'll use your words, of the conduct, use your word. How do we know it's not in the sphere of the child acting, as the experts have said, within their exceptionality?
Well, you look at Ms. Ellerby's testimony here.
Okay.
And Ms. Ellerby said that no other child had had any other complaints, anything close to the conduct that SM engaged in. And I think that's the crucial point. And the Gardner case that we cited to the court, which involved obviously an older demented individual, but there was no expert testimony in that case.
But your problem is that there's a spectrum in many of children who have exceptionalities. There's all kinds of spectrums. For example, not in this case, but autism, for example, it can present itself in very mild, almost subclinical, to very, very pronounced behavior. But that doesn't mean that every child in the classroom is on the same spectrum, and you have no evidence that that's the case, that he is. You know what I'm saying? This is the case that begs of some, because of the complexities of it, that it beg of an expert, at least on your side, to say, no, they're wrong, that this child is not fit. You know what I'm saying? I mean, assuming if such exists or was available.
I do, but I don't think the law requires that. I don't think this case requires that. And I'll explain.
Well, in this case, though, I'm sorry, go ahead and answer. Okay.
No.
In this case, though, if there is a claim to be made of student on teacher sexual harassment, it could undermine the entire educational system for children with special needs.
I don't believe that.
Well, I don't know why not, because it's you told me earlier that based on sex, just he targeted this teacher, even though there are no other male teachers in the classroom, and he could not distinguish between male and females. But you said that was enough.
I do think
if this is typical behavior based on what the experts said, then what to do in the classroom? Well, you said earlier isolate. I guess you meant isolate Ms. Webster.
Isolate Ms. Webster or isolate the
okay, they tried to
both.
take Ms. Webster out of the classroom, and she complained about it and wanted to go back in the classroom. And when Rucker, she complained to Rucker and Johnson about the switch, and when they offered to meet with her, she declined the offer several times, and that's at JA 50 through 56.
Understood.
So I don't know.
And that's an issue of, and I take that point very seriously. That would go to the question of imputed liability. To go backwards, though, to start in September when the behavior started, when the pull up the dress, when the show everybody in the class her underwear happened, and when the walking to and from the classes with the daily assaults, when that happened, absolutely nothing was done, and there were repeated complaints about that behavior by Ms. Webster. And I think that right there would be sufficient, is sufficient. To establish a sexual harassment claim under Title VII.
And then do what? Move her?
And then there's a question, you know, and I think the district court analyzed this, I think thoughtfully. I think the court here could do the same thing and say that her response in November or December was unreasonable, and that would probably end liability at that point. However, all preceding events would still be at issue and would still be subject to the claim.
Can you just, and this I think maybe mixes your second and your third points, but if you can tell me, one question I have is, what is it the school had to be on notice of? I'll just sort of assume for a minute that there's a genuine dispute on this record about whether anything was told to the school in September. But assuming something was, it's apparently sort of in the hallway, sort of complaints about this SM kid keeps pushing up my skirt and things like that. Based on the expert testimony, this is my concern, sort of based on the expert testimony on this sort of second prong, what would a reasonable special education teacher experience as sort of hostile and abusive as opposed to normal behavior? I'm worried that Rucker, even assuming he's told in the hallway, man, like this is a tough assignment, this SM kid keeps pulling up my skirt, would not understand that as a complaint that I have a Title VII complaint here about a hostile and abusive workplace, but would instead assume with the two experts who testified, yes, that must be somewhat off-putting, but you're a special education teacher, so I imagine you understand this is an outgrowth of SM's disabilities and it is not abusive and humiliating behavior. Do you understand what I'm saying?
I do, and I see that my time is
You
going
may
to
answer. You may
expire here. I was going to hope to address that, but go ahead.
No, you may answer Judge Harris' question.
What I was going to say is that even assuming that that would be somewhat ambiguous in the context we're dealing with, she did complain directly about the grabbing of the private areas, front and back, to Ms. Ellerby in that same time frame. And she did so on a regular basis. And she told Ms. Ellerby about these instances when they happened. There was a huge dispute as to whether or not Ms. Ellerby recorded those instances, but she told her, and that right there would be sufficient to place an educator and an administrator on notice. At that point, it becomes Ms. Ellerby's burden or obligation to go higher. And she specifically testified she did not do so. Your Honor, no. Appreciate it. Thank you. I'll address rebuttal.
The question I think this is a tough case. Similarly,
where she testified that nobody else, she had received no complaints of any kind related to any behavior that was remotely similar to what SMN was engaging in. And I think that distinguishes his behavior and puts it kind of at the apex of what we would expect. Yes.
I mean, and conduct like this, because Ms. Ellerby says, I don't get communication teacher understands.
I don't let you a factual inference to say anybody at the school system. And I
with the test, I wanted to address right off the used as complaints, injury reports, which were quite numerous, and we see that. And I think that by Sean, and I addressed it, I moved on, and that was that. And it didn't upset me. He's not the only student who has done that to me. So I think the court clearly understands that this is something that Ms. Ellerby did not understand to be a complaint that would rise to the level of sexual harassment. Those words were not used. And what's clear from the record is that when Ms. Webster did use the word sexual harassment, it was immediately treated as a Title IX complaint. It was investigated.
So I want to back up on that. Does appellee concede that a student on teacher sexual harassment claim is actually cognizable under Title VII?
Yes, ma'am.
Based on what?
Your Honor, what we believe is that—
Is there any circuit authority for that?
We believe that it is analogous to a third-party sexual harassment. So,
right, where people are equal. There's an imbalance here between student and teacher. It's a whole different situation.
Judge Thacker,
I wouldn't imagine you'd want to concede that in the context of special education students.
We agree with you, Your Honor, that this is a power imbalance. And the Western District of Virginia, who has actually heard a sexual harassment case dealing with student-on-teacher harassment in Dean versus Shenandoah County, recognized that power imbalance and said that a teacher's
power— That's a district court case?
Yes, ma'am, 2017. A teacher's power and authority over students strips students' harassing conduct of much of its threatening character, and ultimately found that there was no harassment in that case. To answer your question, what we believe is that the US Supreme Court has told us that social context and common sense must be applied in Title VII sexual harassment cases. And that in this case, that it particularly applies on the severity or frequency of the conduct question. And you can't ignore the social context of this case. You can't ignore the power dynamic between an 8-year-old who's up to your knee and a woman in her 50s who has 12 years of experience and training in working with these children. She's been spit on, she's been grabbed, she's been urinated on, and this is her profession. So the school board acknowledges that it is an employer for purposes of Title VII, and it does not eschew its liability if it were considered to be liable under different facts and circumstances. But the facts and circumstances of this case just do not rise to the level of a hostile work environment. So we think that as an employer under Title VII, there is no different standard, there is no different test. It's still the 4 elements of a hostile work environment claim. But what's so important in these cases is social context and common sense. And thinking about, does this child truly target anyone? And when you look at the record, he is indiscriminate. And I hesitate to use that word because it has a legal meaning here, but he is grabbing everything. And if you look at his point sheets, which I would encourage the court to do, those are at 190 through 334 and 337 through 346. You get a sense of what a day in the life of SM is like. And he is touching everyone's feet when he's under the table during story time. He is taking their lunch, he's destroying their art, he's spitting, he's running away at recess, he's running away at the fire drill, he's running out of the classroom, he's lifting up students' shirts, he's swatting people in the hallway when they by. He is profoundly disabled. And it is undisputed in this case that he is incapable of distinguishing between the genders, and that his mannerisms and behavior are a direct function of his disabilities. And in that social context, in an elementary school where I think it's important to note, it's been a long time since I've been in elementary school, but I don't think that there's been a significant change in the staffing that is predominantly female. And at Providence Elementary School, you're simply just not going to have many males in a classroom or in the school at all. And these children are not going to be interacting with males on a regular basis. I think
Is there any evidence in the record whether or not there was a male in the classroom on a regular basis?
Your Honor, there was no male. It was Miss Ritchie, the other instructional assistant, Miss Webster, and Miss Ellerby, the teacher. And I think that it's important to note the role of an instructional assistant. They are the ones who are going to be spending the most time with these children on a more hands-on environment. So even if Miss Ellerby is not being touched as often, it doesn't mean that she was not being targeted and that Miss Webster was being singled out. I think just as a matter of common sense and day-to-day operations, Miss Webster is the one holding his hand, walking him to the bathroom and walking him to the general education classes and overseeing his activities. So she is just closer to him. Her proximity sets her up to be close to him in a way that unfortunately means she is going to be...
Statistically speaking, she's the one that may be touched more often.
Yes, ma'am.
Because she is in contact with him more often.
Exactly. And that is why the training and her experience is so important. And she understands what that means, what her job means, and I think it's important to note, and we've noted this throughout the case, is that an essential function of an instructional assistant is working with these children to teach them community skills, social skills, and to implement behavioral improvement. And so you're starting with a fairly low bar because these children do not have limits that general education students would know.
Can I ask you a question about the imputation prong at the end? Because I'm sort of stuck on this. Usually we ask whether, and let's assume for a minute the employer is on notice, Mr. Rucker is on notice, I'm just assuming that hypothetically. We usually then say, did the employer take prompt remedial action reasonably calculated to end the harassment? But that's not really what happened here. Here, the employer just took the woman out of the line of fire. And under normal circumstances, right, if someone is complaining that at their law firm, they have a colleague who keeps lifting up her skirt, we're not going to say that's fine. You put the woman in a different office, right? Like that would not be an appropriate remedial response because you haven't done anything to actually make the harassment stop. So this is really just an open question for you. How should we be applying that prong in a context like this?
Well, I think that under the facts of this case, separating them did make the harassment stop. And I think that it's important to note.
But then she didn't want to be separated.
Well, and I think, Your Honor, that what that goes to is whether she really believed it was sexual harassment up to that point. The fact she thought that it was.
This whole thing, in my mind, goes to why there perhaps should not be and could not be a cognizable Title VII claim in a student-teacher context.
I think that the difficulty in making that decision is that you can have, like you do in the Christ case, a 17-year-old, that's the case out of the Eighth Circuit, I believe he was actually 16 years old. He was over 200 pounds. Yes, sir.
6 feet tall.
6 feet tall, over 200 pounds. He was post-pubescent, and he was doing sexual things, and the power dynamic had completely shifted in that situation because the woman was overpowered. He was pressing her against a wall. He knocked her unconscious, I believe, at one point. We don't have those facts here, but I hesitate to concede that there would be no student-on-teacher claim because I can see a situation where, like in Chris, you don't have the control over the student that you do in this case. And he would be more of a threat to any woman that he was around, as opposed to SM being a little boy with, yes, ma'am.
And did Chris involve a special needs student?
Yes, ma'am. He was in a home for.
That's all I needed to know.
Yes.
Well, can I go back to, you said that removing Ms. Webster from the situation stopped the harassment, but I don't understand that. What happened? Did SM stop doing this to whoever the new aide was in his classroom?
Well, I don't know that that's in the record. What we know is that no one else complained about SM's behavior. That's just a fact.
Right, but I think we have to sort of assume your case, and again, I really am just trying to figure out how this would work. Your case sort of, I think, presupposes that SM does not stop doing this because this is in fact an ordinary manifestation of his difficulties. So I think I understand it's not in the record, but what I'm getting at is this is an unusual kind of a case because I assume the new instructor in this classroom, as you've adverted to, these are mostly women doing this work. She's probably a woman and probably the same thing is happening to her. She may not be complaining, which goes to the second prong of your case, that most special education teachers will not experience this as sexual harassment and as abusive. But if we're assuming sort of hypothetically for a minute that the first prongs are all met, that this is in fact an abusive work environment, it would be really unusual for a court to say, but you fix the problem by putting a different woman in to absorb it. So I'm wondering whether we need sort of like whether we should be asking a different sort of question. Instead of, did you take steps reasonably calculated to end the harassment? Did you take whatever steps, would be, and this is what other courts have done in cases like Chris, like they could have helped to address the problem, like better security, more staff, things like that. But I'm really just asking you because I find this really difficult to think about how this prong plays out in this context.
Judge Harris, we agree with you, and we have struggled to think about what would the remedy be in this case if the school board weren't entitled to summary judgment and we moved forward, because it's a job. If no EMT liked blood and had to never show up on the scene because they didn't like blood, who is going to answer a 911 call? I mean, at some point, the employee does not get to choose the remedial measure, but the employer has to balance, I think, its obligation, in this case, as a school board, to provide free and accessible public education to these students and to mainstream them as much as possible. And we can't send them home and impose on the parents a duty to homeschool their children. We can't, in this case, he's so little, there's no detention. There's no, I believe, and I'm sorry, I don't have the citation. In one case that Mr. Hawkins cited, it was sufficient to spank a child. This is a relatively recent case, so it stood out to me, but the court found that it was sufficient to spank a child.
It's a recent case? Okay.
You may recall it, I don't remember it. That was deemed sufficient for purposes of taking care of the problem and showing the child that that behavior was not acceptable. Obviously, the school board does not take that position here, but I think that your question emphasizes how important it is to look at each of these cases on their own facts and their own circumstances.
And on the facts and circumstances of this case, and to your point about it being a job, wasn't Ms. Webster moved from another classroom into this classroom because she had some sort of issue with the other classroom?
Your Honor, I don't think
at the beginning of the year, she didn't want to be in the other classroom.
That's right. We had already responded to her concerns by putting her in this other classroom. And I think that it was what we see throughout her statements in this case is that she wanted to return to her old classroom. She didn't feel like she should have been removed. She thought the teacher should have been removed. And that's consistent here. She didn't feel like she should be removed from working with the children. She thought they should be homeschooled. And at some point, you have to look at the general welfare of the children and the school as a whole and balance that against the employees' needs if there is truly a hostile work environment, which of course here we don't believe that there was. I think maybe that is what makes this case difficult, is that we don't think there was a hostile work environment. So it's difficult to determine what we should have done.
Ordinarily would be, you'd have to request to revisit the IEP and then determine things that you proposed. Then you have a round of people, different psychologists, teachers, and everybody, and then that would prove, then you have a whole set of due process rights and hearings for the child and the parents, right? So it's complicated all the way around.
You're exactly right. There's a lot of procedure required when you're dealing with government, and that would be the procedure that should be followed. I believe that what is important legally in this case is that Ms. Webster bears the burden of establishing an issue of tribal fact in addition to proving all four elements of a hostile work environment claim. And we just don't have any evidence other than her own statements here. As the court has noted, the experts do not think that this was unusual or beyond the pale. They think that it was extremely common, particularly given his age, and that his actions are a function of his disability. And it's important that even if the court were to find that she had met one of the four elements, she has not met all of them, and that is her burden. So we don't believe that with the undisputed facts that we have and using common sense and social context, that the school board is liable in this case, and we believe that it should be found to be entitled to summary judgment. And I'd be happy to answer any other questions.
Thank you, Ms. Russell.
Thank you, Your Honors.
Mr. Hawkins, you have some time reserved.
Thank you. Just briefly, to address first the issue of how Ms. Webster got from her old room to the new room, she did not ask to be transferred, and that's at JA 495. She was actually forcibly transferred.
And she wanted to go back to the other.
She wanted to go back, correct. And that was not the remedy that the school chose. That is an appropriate, deference to the school system. That happens all the time. The employees don't get to pick and choose what they get. The question then becomes, was it an appropriate remedial measure? The response, I would say, to all of the questions focused on because of sex and whether or not a cognizable claim exists, is to look at the Mungeli case, at least the first part of it, because that part we agree with. It relied on Chris. It didn't go into the comparator analysis that we spent some time on a few moments ago. And it said that you must focus on the conduct itself and focus on what happened to the individual. And it said that within this unique context, if you don't find that assaults like these constitute action because of sex, then you essentially immunize schools and like employers from all sorts of behavior that would otherwise constitute criminal behavior or assaultive behavior. And you essentially tell, and I think the words from Chris are insightful here, is that you essentially tell the employees, it says, a court's ruling otherwise would allow the employer to tell its employees that they assume the risk of working with developmentally disabled individuals and that they have no right to expect a safe working environment. And I want to dovetail that to say that in this case, and I know we've had some questions as to whether or not SM was acting in a normal manner for somebody in his condition, look at the May 9th letter from Dr. Rucker, which categorized the March 14th, the March 13th incident as a Title VII complaint, a founded Title VII violation. Title IX is exactly the same as Title VII in the sense that it requires behavior to be committed because of sex. If SM's behavior in March was because of sex, then all of the other behavior, although not as extreme, is exactly the kind of behavior that is because of sex. And so we submit we submit that a claim should be cognizable. And if the court chooses not to recognize a claim like this on these facts or any similar facts, it essentially shuts the courthouse doors to all individuals in Ms. Webster's position, whether they be an instructional aide or whether they be a teacher, and puts them essentially at the mercy of the classrooms they teach in and at the schools that they work for. We don't submit that should be the law. And we submit that teachers in this context should be afforded the same rights as everybody else in the sense that they should have no higher burden than anybody else in a Title VII sexual harassment claim. We submit no circuit has spoken on this. We submit the Fourth Circuit should recognize the claim and should allow Ms. Webster to proceed to trial. We ask that the decision be vacated and reversed and that we be allowed to go to trial. Thank you.
Thank you, Mr. Russell. And again, thank you both counsel for your arguments. We would love to come down and shake your hands as our normal custom in the Fourth Circuit, which we really love. But nonetheless, that we appreciate your being here and thank you for your arguments. Safe, stay well.
Thank you.
Thank you, counsel. Ready to proceed?
I don't need a break.
We'll proceed to after the court is policed, we'll proceed to our last case for this morning.
Do you not have your microphone covered?
I don't have a microphone.
Oh.
Yeah.
Well, then I won't have one.
It's okay. I got it.
They need to.
Thank you.
No problem. You all
Or
good?
prefer if I took the mask off or kept it on? During
No, it's your option.
Okay, all right. Good morning, may it please the court. I represent Colonel Derek Harvey, and we're asking the court to reverse the district court and remand the case for a trial on Colonel Harvey's defamation and false light claims. I'm going to be addressing the dismissal of the case under Rule 12b-6. And I just want to begin by with what I would commend the court is the correct lens to be looking at this case on a 12b-6 motion. The district court in a number of places looked at the case through the lens of a reasonable Republican, or what a reasonable Republican would view as being odious or offensive. And I would submit to the court that the leading case that we cite is Washington Post versus Challoner. It's a 1919 decision. And what the Supreme Court of the United States said in Challoner very clearly was that in order to determine whether a statement is defamatory, it must be read and construed in the sense in which the average reader or the reader of the article would understand it. In this case, we have alleged in paragraph 2 of the amended complaint 5 statements that Colonel Harvey contends contain defamatory material. Now, in the brief of appellant, we amalgamate them as statements 1 and 4, 2 and 3, and 5 really goes along with 1 and 4. So this is a false attribution.
5 statements, the difference between the original complaint and the amended complaint?
Well, Judge Thacker, they're the same statements because they come from the same article. The question is.
Okay, so what's the difference significantly between the original complaint and the amended complaint?
Sure. The significant differences, as we point out in the brief and in the red line version of the amended complaint. We filed a red line version of the amended complaint in which we clearly pointed out what was being added, what was being deleted, what was being clarified. And this is on page 5 of the brief. We add material, we add allegations to paragraph 3 of the amended complaint, paragraph 5, paragraph 6, and paragraph 38 of the amended complaint. The purpose of these additions, the reason that they're material additions, and even the district court went to some lengths to try to distinguish the cases that we cited. The reason that they're material is because this is a false attribution case. And in the amended complaint, we make that clear. We make it clear that CNN published an online article and went on a broadcast, and they said that Colonel Harvey said certain things. And that's what makes this a false attribution case. They said that Colonel Harvey said that the timing of this trip to Vienna and the timing of the meeting with the corrupt Ukrainian prosecutor by the name of Shokin was all done deliberately. It was all done as part of an effort to deceive members of Congress. And the reason that that's defamatory, as the Supreme Court of the United States pointed out in the Masson case, the leading case is Masson versus the New Yorker, is because Colonel Harvey never made those statements. He never made those statements to Lev Parnas, not in any particular. So when the court looks at these statements, you have to break them down. Lev Parnas, CNN reported that Lev Parnas said that Colonel Harvey said that they went to Vienna. That never happened. They never went to Vienna.
Do we have to first determine whether Colonel Harvey is a public official or figure or not in order to determine what lens we view these statements through?
Judge Thacker, not for purposes of determining whether the statements are defamatory. Your point is well taken on the question of whether or not Colonel Harvey is required to allege actual malice. And I'm going to presume for purposes of my argument today, that he is a public figure, that the court is going to not going to address the New York Times issue. Rather, that's a matter for the Supreme Court of the United States. And I would submit to Your Honor that even under the—
So assuming the statements are defamatory and Colonel Harvey is a public figure, as you've conceded, what's the evidence of actual malice?
I can point the court to paragraph 41 of the amended complaint, and I would commend 41A, 41D, and 41I of the amended complaint. When the court looks at those paragraphs, there are three sets of facts that are alleged that give rise to a plausible inference of actual malice at this stage of the proceeding. And the first plausible allegation of actual malice is the reliance upon an unreliable source. The amended complaint goes to great lengths to show that CNN knew that Lev Parnas was a totally incredible source. We point out that even CNN anchor Jake Tapper pointed out on air saying that Lev Parnas was totally incredible. Before they published the article, they themselves, the same author, Vicky Ward, referred to their source as a radioactive wolf in sheep's clothing. So if they knew that their source was totally unreliable and they published statements, the statements of that source, this court has held in the Wells case, Wells versus Liddy, that is enough to survive a summary judgment motion on the question of actual malice. The Supreme Court of the United States in the St. Anant case, which is really the leading case in these issues, has said that that is one of the essential types of actual malice, the reliance on a totally unreliable source. And I would also point out this, when the court listens to the broadcast, the Chris Cuomo primetime broadcast, even Chris Cuomo refers to Lev Parnas as, quote, the shady guy. So CNN clearly knew that their source was totally unreliable, that he was a fraudster, a hustler, a radioactive wolf in sheep's clothing, and yet they relied on his statements. And his statements were, as we allege in the amended complaint, totally fabricated. And that's another way the St. Anant court has said that you can allege actual malice is by showing that the events never occurred, that they were completely fabricated. And we allege that in paragraph 41I of the amended complaint. And the last aspect of the actual malice allegations are the rule of law that was announced by the Supreme Court in the Connaughton case, Hart-Hank versus Connaughton. And that is where the defendant fails to interview a known source who's readily available. In this case, there couldn't be a clearer example of CNN deliberately evading the truth, is what the Supreme Court of the United States has said in Connaughton. There couldn't be a clearer example than this case. So Viktor Shokin, who is the corrupt Ukrainian prosecutor who CNN and Parnas say that my client, Colonel Harvey, and his superior visited in Vienna in December of 2018, that particular corrupt Ukrainian prosecutor was available, and he, for reasons that are completely unexplained, CNN failed to interview him. He was interviewed by the Washington Post, and he denied that he ever knew Parnas, ever met him, and he was later interviewed, as we allege in the amended complaint. He was later interviewed by a One America network.
I just want to go back to something you said when you first stood up, something about reasonable Republicans. Were you saying that the district court viewed this case through the lens of a reasonable Republican? Or I wasn't understanding where you were going with that.
The district court viewed the allegations in this case, the effect of the allegations in this case, on what their effect would be on essentially a reasonable Republican.
Say that somewhere. I was looking for that.
There's a reference in his opinion to all that was happening in this case. There was nothing wrong. There was no defamatory element to these statements, because even the Republicans were saying that there was nothing wrong with interviewing Ukrainians about Joe Biden and his son. So the court was saying there was nothing defamatory about that because even the Republicans were saying there's nothing wrong with it. But that's not what they said about Colonel Harvey. They didn't. The CNN just didn't just say, well, Colonel Harvey accompanied Congressman Nunes to interview a Ukrainian prosecutor. That's not what they said. They said that Colonel Harvey told Lev Parnas that they essentially hid the reason that they went over there and hid the reason that they interviewed this prosecutor. And I just want to say that they never went to Vienna. They never interviewed a prosecutor, and they never hid anything from anybody. And so every aspect of this CNN article is false. It's false on false. I see my time is up. If there's any other questions, I'd be happy to answer them.
Oh,
thank you, Your Honor.
Thank you, Mr. Biss. Mr. Lipper.
Thank you. Excuse me. Thank you, Chief Judge Gregory, and may it please the court. I'm here on behalf of Appellant Joseph Meadows, who is appealing the sanctions award against him. And whereas Mr. Biss was addressing simply the merits of the First Amendment complaint and whether it should have been dismissed, the question in terms of the sanctions award is different. Now,
is it only the sanctions award against Mr. Meadows that's being appealed?
I represent only Mr. Meadows, so I believe my co-appellant does address sanctions briefly in his brief, but I, as a lawyer, am here on behalf of Mr. Meadows only. And I think what ultimately one of the core errors that the district court made was to conflate the merits question. Did the first amended complaint make enough changes to enable it to survive a motion to dismiss, on the one hand, with the sanctions question, which is really, was it bad faith or vexatious?
You said it was, right? I mean, I totally understand. You don't want district courts running around inviting amended complaints and then saying, this one's not good enough, sanctions. But I thought the district court clearly understood that he found bad faith. He found that this was vexatious.
But he didn't, I mean, he said that there was bad faith and that it was vexatious, but there was no real analysis or discussion of it. You know, only one of the cases he cited even involved an amended complaint, which was a case from a bankruptcy court in the Northern District of Florida from the early 1990s. And although the facts in that case are not elaborate, it looks like that amended complaint was close to identical. And here, the district court acknowledged that there were changes. The district court specifically noted there were changes to the First Amendment complaint. He said that were presumably designed to address the concerns that he had addressed in his prior order. Now, he said they don't suffice to address his concerns, but again, there is nothing further that specifically identifies any bad faith or vexatiousness, and there's no reason to think that. If everything in the record suggests that Meadows was doing his best to fulfill his ethical obligations to his client, because if he had not, and Meadows has not been involved in any other cases involving Congressman Nunes, he has not been involved in any cases with my co-appellant's counsel before, you know, and if he had refused to allow the complaint to be filed, or if he refused to put his name on the complaint, which would have meant the amended complaint, which meant it couldn't have been filed, he would have been violating his own ethical obligation to his client, which includes a duty of loyalty and a duty of zealous advocacy, because there was important information that was contained in the First Amendment complaint that was important. You know, for instance, the district court had in his original order said that Harvey could not show that his reputation suffered because he was working for a leading Republican, and the Republicans were defending the efforts in Ukraine to solicit information about Biden. But in the First Amendment complaint, there was specific information showing that Harvey was situated differently than the average Republican elected official, that he had a history as an intelligence officer with a security clearance, and that in his professional circles, which goes beyond his job as a congressional staffer, these types of allegations would harm him. They could affect his future employment, and they could even lead to a security clearance being revoked.
Can you speak to don't you have an argument about the lack of process or meaningful process, at least before sanctions were imposed?
Yes.
Basically via footnote?
Yes, we do. And I think that also goes to, even if it were theoretically possible to find bad faith, there was no opportunity for Meadows to be heard, either in writing or orally, much less present evidence to explain why he exercised the legal judgment that he did, and why he, didn't order his name be taken off the First Amendment complaint. There were violations of the local rules and the federal rules. Federal Rule 7 requires an actual motion be filed, not just a footnote to the very last sentence of a supporting memorandum for a different motion. There is a local rule, 105.1, that requires that every motion be supported by a memorandum, and there was no motion for sanctions, let alone a memorandum in support.
So can I ask you about that? The district court can impose inherent sanctions sua sponte, right, without a request from a party at all. So just in this case, does it really matter whether the formalities of whether the request was properly made? Didn't the district court also rely on inherent authority?
I think it does, and I'll say for two reasons. So first of all, the district court did not view this, and you can look at it, the district court's own words suggested he did not view this as a sua sponte exercise of inherent authority. If you look at page 318 of the joint appendix, the district court says CNN requested that it should be awarded fees, costs, and expenses pursuant to Section 1927 and this court's inherent authority, and proceeded to analyze it as such. So the district court was treating this as an invited request, not a sua sponte exercise. But the second point, and I think this is more fundamental, is that Rule 7 and local rule 105.1 and the local rule 105.8 requiring a response before sanctions are imposed are not mere formalities. They are important protections and provide important guidance and process to the attorney under threat. And I think it's an important, and a lot of the briefing, including CNN's brief in this case, was sort of suggesting that, Meadows could or should have said more earlier in response to the footnote. But first of all, Meadows is familiar with the rules and is entitled to rely on them. But second, if Meadows had, based on this sort of Rorschach test of a quasi maybe motion for sanctions, decided he needs to sort of immediately sort of pull out all the stops and hire his own counsel and disclose client confidences or work product, that is undermining not only his duty of loyalty to his client, but his duty of confidentiality. And he would have had to have been doing that while the underlying First Amendment complaint was still before the district court. And that would have been extremely damaging to his client. And I think Meadows, took his own ethical obligations to his client seriously. And so I think an attorney looking at this.
Can I just ask you a question? Because I don't, genuine question, I don't know. Is that customary in a case like this, that when someone is seeking sanctions like these, covering costs for an appeal, or I'm sorry, for the response to the amended complaint, that the lawyer and the client would split and the lawyer would hire his own counsel? Is that usually how that plays out?
Well, I think it depends, but I think it certainly has happened. And so, for instance, but I think one of the things that was missing here, and I think this explains it, is very often you will get an order to show cause, right? And so if, for instance, the district court had saw the footnote, agreed with it or preliminarily agreed with it, dismissed the First Amendment complaint, he could have then ordered counsel to show cause why they should not be sanctioned. And at that point, perhaps, he might have, especially if he had if he thought there were otherwise confidential information that would have helped him. But I think it's that underlying notice that lays out the rules of the road. And here, Meadows was.
Someone would have, the lawyer would have hired his own counsel?
I think it depends. I mean, I think, excuse me?
That just seems sort of like a lot.
Well, but I think, sanctions against a lawyer are professionally devastating. I mean, I without disclosing anything confidential, if you look, the sanctions award against Meadows or against all counsel and parties jointly and severally was for $21,000. Meadows hired counsel to file a motion for reconsideration and has hired counsel for an appeal. And he did so because, as courts have recognized, the professional consequences for sanctions, they're stigmatizing, they're embarrassing, they can follow the lawyer around, they have to be disclosed on insurance applications, on other court admissions. It's a real badge of shame, for lack of a better word. And it's because those consequences transcend the cost of the sanctions or the particular case at issue. They are, I think, taken very seriously when a sanctions request is made, and allowing them in that circumstances would have a significant chilling effect on future attorneys who would, do not want to risk having this happen to them. I see my time has expired. The court has no question.
You wanted to finish your thought there? You can.
Sure. I want to make sure I'm keeping my rebuttal time, but
you're not taking away from that. I thought you were in the middle of a thought.
The only thing I say is, that another lawyer looking at this order, both the process and the substance underlying it, would think very hard about representing a client, an unpopular client with a controversial case, and would think doubly hard about filing a First Amendment complaint that sort of ultimately proves unsatisfactory to the district judge. And that is why ultimately I think not only was Meadows forced, not only was Meadows punished for fulfilling his ethical duties to his client, but the decision in this case will chill attorneys from zealously and loyally representing clients in the future.
In reviewing this, do you think we should look at your client? I know it's like a no-brainer, but I trust you as counsel. You're going to look at it more than just that. Take it for what I'm asking the question. Do you think we should look at your clients in a different light because he was local counsel?
I don't think it's merely because he was local counsel. I think that, although I think it's one factor, ultimately when there's sanctions premised on bad faith, there has to be an individualized inquiry, right? And so not everyone whose name is on this is not like Rule 11, whereas if your name is on the offending paper, you are on the hook. And so I think you have to look at his circumstances individually. It might include, that some of the factors to consider might include.
Which is what the motion to show cause would have illuminated the district court about.
I think so, right? In order to show cause would have.
There might be a distinction between Mr. Meadows and Mr. Biss.
Right, there might be a distinction, given his secondary role. There might be a distinction given his lack of, there's no indication that Meadows has some sort of ideological axe to grind here, that he was doing anything other than trying to help his client. And there may have been specific circumstances underlying the filing of the amended complaint or why Meadows, felt that he couldn't veto its filing. All of that would be taken into account in the individualized inquiry. So I would say the fact that he had a secondary role as counsel, it's not a dispositive, but it's certainly relevant to the individualized inquiry, none of which happened in this case.
Thank you, Mr. Lipper. Mr. Hentoff.
Thank you, Chief Judge Gregory. Good afternoon, Your Honors. May it please the court. I'm Thomas Hentoff with Williams & Connolly. I represent the defendant appellant Cable News Network. I'd like to start by addressing the appeal of the district court's Rule 12b6 dismissal. And I'd like to focus my discussion on two of the grounds relied on by the district court. First, the statements that the statements that are about Colonel Harvey that he challenges as a matter of law do not rise to the level of defamation. And one point that I would like to make is Mr. Biss, in characterizing the two CNN reports, said that Colonel Harvey deceived Congress. That is Mr. Biss's assertion. There's nothing in either the CNN article or the transcript of the discussion in which they say Colonel Harvey deceived Congress. Quite to the contrary, they pointed out that Colonel Harvey had told Mr. Parnas that his boss, Congressman Nunes, had decided to comply with disclosure rules by taking the trip before there was a requirement to disclose them to the incoming Democratic majority.
Well, Mr. Biss also said that CNN anchors said that Mr. Parnas was incredible and unreliable, and so that they knew he was unreliable, and therefore that's evidence of actual malice. What's your response to that?
Yes, Judge Thacker, and that was the second point that I wanted to address, is the failure to plausibly allege actual malice. So I think that Mr. Biss left out from his discussion and from his brief two really important facts that are evident from the 12b6 record that completely negate any plausible allegation of actual malice. The first is, and by the way, I'd like to make a correction. Mr. Biss said that Jake Tapper made a statement that indicated that he didn't believe that Lev Parnas was believable. The record shows that that statement was made several weeks after the two challenged reports. That's not relevant to or probative of the state of mind of Vicky Ward several weeks earlier when the reports were published. So the two things that Mr. Biss left out. The first is the source that CNN relied on was not Lev Parnas. CNN relied on Joseph Bondi, the attorney who was representing Lev Parnas in the criminal case. And this attorney was willing to go on the record by name to tell the world that his client, who had been subpoenaed for documents and testimony by Congress in the impeachment inquiry, was willing to testify under oath about what he talked about the efforts to gather information in Ukraine. And there's nothing in Colonel Harvey's two briefs or Mr. Biss's argument today that would say that CNN had any basis to believe that this attorney was going to trash his own reputation by making that promise about what was going to happen. So that's an important thing that's missing. It also distinguishes the cases that Mr. Biss relies on. For instance, Wells v. Liddy, which is a Fourth Circuit case. That's an extreme case. The facts of it are very interesting. The defendant was G. Gordon Liddy of Watergate fame. And he testified that he actually didn't believe the source. And also there was evidence in the record that the source was delusional, believed things that weren't there. This was someone that totally could not be relied on. But here, by contrast, CNN was relying upon the attorney who was representing Mr. Parnas. The second thing that Mr. Biss leaves out, and I thought it was striking that he said that CNN engaged in a purposeful avoidance of the truth, which is language from the Hart-Hanks case. And yet, the face of the article shows, and the complaint does not in any respect dispute, that CNN, after getting this information from Mr. Bondi, went directly to Congressman Nunes. And over the course of 2 weeks, they tried to speak to him twice. And they actually reached Colonel Harvey, who refused to speak with them. And the face of the article also shows they reached out to Mr. Shokin. So in this case, Colonel Harvey had, and his boss, Devin Nunes, had an opportunity before publication And in fact, with Congressman Nunes, it was 2 weeks. They had an opportunity to say, this is wrong. You should not publish these statements. They're false. They forwent the opportunity that CNN gave them and gave CNN no indication that they were going to say that was false. And then CNN publishes it. Again, that's the opposite of the purposeful avoidance of the truth. CNN went to the subjects, asked for comment. Subjects refused to comment. The story's published, and then they sue for defamation. That is completely a whipsaw. It is the opposite of what this court talked about in Fairfax v. CBS, which was a case in which it affirmed the dismissal on 12b-6 of, at the time, the Lieutenant Governor of Virginia, on the ground that the allegations of actual malice failed to satisfy Iqbal Twombly. In that case, this court forcefully talked about, citing Times v. Sullivan and its progeny, the importance that when news organizations are reporting on government leaders and public officials, that they have protection, that they can't self-censor and be chilled, that if they make a mistake and if there is an alleged falsity, they will have liability. The idea that the important public officials, when they're contacted, will refuse to talk and then turn around and sue, that turns those concerns on their head. I guess I'd finally note on the merits case, unless your honors have other questions, that the district court quite correctly noted that almost all of these reports were about Devin Nunes's plans, Devin Nunes's decisions, what Devin Nunes had said on one occasion and what he did on another occasion. And in fact, it was Devin Nunes who filed the lawsuit immediately after, or within a couple of weeks after the publication. What little is said about Colonel Harvey is simply not defamatory.
Can I ask just one question about that on the, the sequencing statement you were talking about before that, let me make sure I get this right, that Harvey told Parnas that Nunes had done the scheduling to avoid disclosure to Congress. What I understand Mr. Harvey to be arguing now, at least, is that that was defamatory as to him because it makes him look like a big blabbermouth who's revealing all this information to this unreliable guy, Parnas, about his boss. Does that work?
Judge Harris, I'm understanding Mr. Biss to be making a totally opposite argument.
Oh, okay.
And I think saying this is what he's saying now, this is what this case focuses on. He's saying that the CNN article portrayed Colonel Harvey as a liar, not someone who was a blabbermouth to Mr. Parnas, but as someone who lied to Mr. Parnas about the true reason for the sequencing of the trip. And that is completely fails to meet the standard for what is a defamatory statement, which under the law is relatively similar across different states, but in Maryland, it is to subject the plaintiff to public scorn, hatred, contempt, or ridicule, thereby discouraging others from having a good opinion of them or dealing with them. And I think most significantly, nothing in the four corners of the article that are in the record before us state or suggest that CNN said that Colonel Harvey was lying. In fact, Judge Harris, you said it made him seem like a blabbermouth. And of course, this court, you judges are the gatekeepers to determine what's a reasonable reading of what the challenge reports say. And in this case, the only reasonable reading is simply that, which is what the district court said, Colonel Harvey provided information to Lev Parnas about the reason for the timing of the trip. Now, does that make his boss look bad? Not really. And again, that's what the district court found. Congressman Nunes complied with the complied with the disclosure rules. He didn't violate the disclosure rules. And of course, this is, we live in a world in which the two major parties are divided, they're contentious, and they're doing the work of government on opposite sides of many issues. I don't think anybody would say that when, both sides have investigative powers, that it would be defamatory to say that someone didn't give a heads up to the other party and say, I know you're working on this hearing, but this is what we got going. It's simply not defamatory to say that somebody failed to do that, especially when the article made clear that Congressman Nunes was complying with the disclosure obligations. So there's nothing here about Colonel Harvey that's defamatory. I can turn to the sanctions question unless your honors have any further questions about the 12B6 dismissal.
I do want to hear about the sanctions.
Well, I guess I'll start with the merits of the sanctions order. The district court, well, first of all, of course, we previously have been talking about a standard of review that was de novo, and now we've moved on to an abuse of discretion standard of review. Judge Bennett was the person who was there, who was reviewing things in real time. When Colonel Harvey filed the amended complaint, Judge Bennett immediately ordered a status conference and a scheduling conference, got everybody on the phone the next day. And he set an expedited briefing schedule where CNN only had 7 days to file its motion to dismiss the amended complaint. So what Judge Bennett found was that he had told the plaintiff that he could amend the complaint if he could fix the manifest deficiencies. And then he looked at, anyone can look at the red line that Mr. Biss was talking about and see that there was not even an attempt to fix the manifest deficiencies. And I think the best example that I can give is the failure to do anything of substance to plausibly allege actual malice. The inability to allege actual malice defeats the claim.
Did the possibility of sanctions come up in that status conference, or was the first time that came up in the footnote in the motion to dismiss?
Yes, Judge Thacker. The first time sanctions came up in the case was in our motion to dismiss the amended complaint.
Okay, so then that cannot be the court's inherent authority. You were making that by way of motion, which it seems like Rule 7 would apply to, correct?
Well, a couple of things. Number one is we did suggest that the court...
At least it could not be sua sponte, the court's inherent authority, I should say.
Well, Your Honor, we did suggest it first, and the judge did respond to it. We complied with Rule 7 because Rule 7 says a motion needs to be made in writing. It was in writing. We had legal argument. It wasn't a footnote, but we did explain why the conduct was in bad faith and was sanctionable. We included in the draft order a request that there be sanctions. And at any rate, that's the answer to that question. But just to finish my thought on the merits, I believe Mr. Biss said that there were changes in this brief. There were changes to paragraph 41, and that's the evidence of actual malice. There's essentially nothing has changed. There are a couple of conclusory allegations were added, but there was not even really an attempt. So in other words, the judge said, if you can cure the deficiencies, file an amended complaint. And if you just look at the actual malice allegations, they're essentially unchanged. It couldn't have changed the result of the judge's ruling. And it's the same with all the other allegations. It's just that the actual malice allegations are so clear because there's so little additional red ink, and what is added is just conclusory or not new facts.
The concern I have, and I want to give you a chance to address it, is that, and I think this happens not infrequently, that parties, sometimes pro se, sometimes just poorly represented, try, sometimes quite ineptly, to amend a complaint and are unsuccessful. They are unable to address the pleading deficiencies that the district court identified at first. And we obviously don't want a system in which all of those people get sanctioned for failing to amend a complaint to a district court's satisfaction. And what's supposed to separate those cases from this one is the bad faith. But the district court really didn't say much about why he believed there was bad faith here. There wasn't a show cause hearing, so we can't assume that it was something that happened at the hearing. Mostly he seems to talk about the district court seems to talk about the fact that the brief came in after close of business, but if that's permitted by the rules, I don't really understand why that's such a big deal. So where's the evidence here that I can see on this paper record of bad faith versus inept lawyering?
I guess I have to start by not. I don't want to characterize the lawyering on the other side in the district.
Oh yeah, I'm sorry. I didn't mean to either. I'm talking about my sort of hypothetical concern that we don't want to be penalizing inept lawyering in general writ large. I'm not talking about the lawyering here.
I guess what I would say is, from the perspective of Judge Bennett, looking at the advocacy, he made a judgment that he was not looking at inept lawyering. He was looking at relatively sophisticated legal argument and an understanding of what was required with an amended complaint. And with regard to the timing of the filing of the complaint, again, I'm only a reader, so I don't know. I can only see, read what Judge Bennett said, but it seemed to me that he thought that counsel were dragging the case out, and that if they didn't have really anything to add, why do it at the last minute? That struck me as the only relevance of it. Not that there's anything wrong with filing on time. So
back to the process question I had. It's my understanding from your responses that it's your position that you complied with Rule 7 by putting the motion for sanctions in this footnote, and that was good enough. Is that your position?
Yes.
Okay. What about our case? It's a 2008 case, Casarelli, where we held that plaintiff's request for leave to amend only in a footnote in response to defendant's motion to dismiss, and again in the final sentence of their objections, did not qualify as a motion for leave to amend pursuant to Rule 7.
I'm not remembering exactly the procedural posture of Casarelli as I'm standing here, but in reviewing all the cases, the pattern that I generally found was that the courts of appeals recognized the broad discretion of the district courts intended to. Let me say this. It's clear there are cases where a district court says, you only put that argument in a footnote, I'm not going to consider it. And the court would then be within their discretion to say, I'm not going to consider it. What I'd say here is we did include the argument in the footnote. We also included it in the order. And we talked at the beginning of our motion to dismiss about the vexatious nature of the failure to make any meaningful changes to the amended complaint. And then as a matter of fact, it wasn't missed. And I think possibly the key procedural fact is, well, first of all, we made the suggestion of Section 1927 sanctions, and Section 1927 sanctions are against the attorneys only. So Mr. Meadows was on notice that this was a request that he be sanctioned. And they could have said, under the local rule, we understand that responses are not required until ordered, but they didn't do that. They responded. And that's what Judge Bennett said. He said there was a response.
They did say, although plaintiff and his counsel need not respond to an argument as opposed to a motion for sanctions, and then they responded. So they did say they're not required to.
Well, that's sort of kind of like waving the waiver.
Put on their entire sort of what they would say if they had been given full process.
Well,
I could enough footnote.
I could respond I'm out of time, but I could respond very briefly on 2 points. Sure. So the first is Mr. Meadows really, has sort of even today on appeal And by the way, he hired counsel to file a motion to reconsider. He never said there's something special that might violate the attorney-client, relationship that I need to proffer under oath. I mean, the arguments have not been.
Sure when he would have said that.
Well, he could have said it.
Issue I'm having.
So I guess my basic answer to that is Mr. Meadows says that he did not have adequate process, but he had notice and he didn't have surprise. And he did move to reconsider, and Judge Bennett did at the end of the order denying the motion to consider, he went back to the merits and said why these arguments were not sufficient. And then the final point, which we make in our appellate brief, is that there is a defect in the notice of appeal in which Mr. Biss did not, with objective clearness, include himself as an appellant. And I would just note something that even the docket sheet in this case lists the appellants as Colonel Harvey and Mr. Meadows.
Can I ask you what you think follows from that? I mean, if I assume whether or not he appealed, we have jurisdiction, right? Because, just like if you've got more than one plaintiff and one of them has standing, that's enough to get the matter in front of the court. And so if we vacate the order, the sanctions order, I assume he's still not going to have to pay because there's no order. And if we don't, he has to pay. So does it matter?
Well, if a sanctions order is entered, one must assume that the order was entered jointly and severally against the three entities. And if someone doesn't appeal an order, it's an interesting question as to whether if the order is vacated, is it vacated as to all three or just the two who appealed?
Mr. Hentoff, if you know this, was the district court aware of the entire CNN article at the time of the first complaint? The entire, not just the pleadings, but the entire article?
Yes, Chief Judge Gregory, we attached the entire article to the original motion to dismiss.
All right, now here's my question then. It's somewhat of a counterfactual, but would we be in the same posture if instead the plaintiff said, upon knowing that their complaint was going to be dismissed without prejudice, how you have to say, they said, and then offered the opportunity to amend, and they said, nope, let it ride, and appealed here. Would they be in the same situation in terms of sanctions there, you think?
Totally different situation, Your Honor. And that's what we said. Nobody has to file an amended complaint. You've got every right to just saying, I'll take a dismissal with prejudice and I'll appeal.
Now, the other side of that is this. I thought you might say that. Is this. And I'm using a term that's normally not used, but you'll know what I mean by this. But is this almost somewhat like invited error in the sense that since the district court knew the entire article, giving them the opportunity to amend, well, what would be there to amend? I mean, they pretty much, the facts are the facts. And because that was the, if you will, the four corners, basically, of the alleged defamation, and they had it, it's almost like saying, well, why are you offering me the opportunity to amend if you see exactly what the four corners of it is? It's almost like saying, well, it must be something here. Maybe we didn't put this right here like we should have. We should have led here. We should have done that. You see what I'm saying? It's not really invited error because obviously that's using a different kind. But I know as a counselor, as all you are, an experienced guy, you know what I mean by that. And say, well, Judge, why are you offering it to me? I need to do something. We're all A-type people. It must be something here I can do better. But isn't that sort of like where we are in sort of sanctions?
Well, Judge, I think any district judge has to pay attention to Rule 15, which says leave to, especially the first request to amend should be freely granted. And, the complaint's an interesting thing because the plaintiff is the, boss of the complaint. They can put in whatever they want. And so I don't think a district judge really knows what are the what are the allegations that the plaintiff didn't include for any particular reason. So I don't think it was a trap or anything like that.
No, not that. But I see, the point well taken. It was beyond the four corners, perhaps, because the court wouldn't know that.
All right, well, Thank you, Your Honor.
All right, thank you, Mr. Hentoff. Mr. Lipper, you have some time reserved.
Thank you. I want to address a couple of things that Mr. Hentoff said. So first, Mr. Hentoff suggests that at no time did Mr. Meadows indicate that there was confidential information that he might need to divulge. That is simply false. And I want to point you to two points in the joint appendix. First of all, joint appendix page 328, which is the supplemental motion to withdraw that Meadows filed a few days after the sanctions order. And he says, quote, Mr. Meadows would like to defend himself against the imposition of sanctions through his own separate counsel by moving for reconsideration, filing a separate brief, and presenting oral argument. But mounting a full and fair defense on his own behalf may require that Mr. Meadows take positions that are adverse to the interests of Plaintiff Harvey or Mr. Biss, or that he divulge confidential information about the representation as he is permitted to do under Maryland Rule 19-301.6 B5, and which he would seek to do via an in-camera submission. And yet he was never given that opportunity. And then second, on pages 361 and 362 of the joint appendix, in his reconsideration motion, he doesn't divulge the confidential information publicly for obvious reasons, but he does allude to some of the pressures that he was facing in deciding whether to veto the First Amendment complaint or not. But I want to pick up on a couple of other things that Mr. Hentoff said, because I think they show that if Mr. Meadows had acted in the way that Mr. Hentoff is suggesting he should have, Mr. Meadows would have been breaching his own ethical obligations to his clients. The first involves the discussion at the beginning of the argument between Judge Harris and Mr. Hentoff about the sequencing issue. And I think Judge Harris sort of suggested that the real harm here was that it made him look like a blabbermouth. And in fact, that issue and the consequences of it was something that was added to the first amended complaint. Because paragraph 5 of the first amended complaint, you can see the black line on appendix page 138, said that the suggestion that Harvey had sort of, threw his boss under the bus was, quote, highly prejudicial to plaintiff's employment. And then on page 158 of the appendix, paragraph 41E, that the disclosure, quote, hurt plaintiff's relationship with Nunes, because far from suggesting that Nunes was going out of his way to comply with the letter of the law, it suggested that he was going out of his way to evade the spirit of the law. And as a staffer, that can be very damaging to your employment if your boss can't trust you. Had Meadows vetoed the filing of the First Amendment complaint, that additional detail, which prompted a colloquy about the merits of the First Amendment complaint on appeal, would not have been there, and Meadows would have been deserving his client's interests. The second point I want to make goes to Mr. Hentoff's point about the actual malice issue. And it is very clear in the opposition to the motion to dismiss the First Amendment complaint that the brief is preserving the argument for later appeals that the actual malice standard in New York Times v. Sullivan should be overturned. Obviously, the district court, or this court for that matter, cannot disregard New York Times versus Sullivan. But that argument, if it is not made in the district court and then not made in the Court of Appeals, would be forfeited by the time it got to the Supreme Court. And so even if there are now 2 U.S. Supreme Court justices that have written separately to suggest Sullivan should be reconsidered, whether you or I agree with that, his client wanted to argue it. And if he had failed to preserve those arguments below, he would have been forfeited. He would have been undermining his client's appellate rights. And so again, what the district court's order did and what CNN is suggesting Meadows should have done was to violate his duty of loyalty, violate his duty of zealous representation, violate his duty of confidentiality, by vetoing the filing of a First Amendment complaint, and then by divulging confidential information at the first hint of a footnote suggesting sanctions. Neither is fair to Mr. Meadows or any other attorney, but even more importantly, neither would have served Mr. Meadows' client well, and neither would serve clients well in the future. If the court has no questions.
Thank you, Mr. Lipper. Mr. Hentoff, thank you for your as well for your arguments. We would love to come down and greet you in our normal fashion, but we can't do that. But no, nonetheless, that we very much appreciate your fine arguments and helping us on these very thorny issues. Thank you so much. I wish you well, and please be safe. With that, I'll ask the deputy clerk to adjourn the court till this afternoon.
This honorable court stands adjourned until this afternoon. God save the United States and this honorable court.
Thank you very much.